May please, Your Lordship. I'd like to mention item number 36. Kindly matter be taken at 2, Your Lordship. 36. It will be this. There's a VC matter at 2, Your Lordship.
At 2, okay.
Yes, Your Lordship. Oblige, Your Lordship.
May it please, Your Lordship, with the consent of the other side, my lord, beg to mention item number 17, my lord. Here I need to obtain some instruction. It may take up next week, Lordship permits, my lord. The small instruction I need to obtain whether they have received the salary or not, my lord. In the next week.
You're for the petitioner.
Petitioner, my lord.
Item 17,
17, my lord.
as paid for by the learned counsel for the petitioner. Matter stands adjourned for a week to enable him to obtain instructions in the matter.
Deeply obliged, my lord. May please, Lordship, I beg to mention item number 13. Lordship, the matter has become infructuous. So I
30.
withdraw.
30.
On 3.
Your good name?
Respondent. Petitioner. I'm for the petitioner.
Yes, what is your name?
R.A. Ahmed.
Mr. R.A. Ahmed, learned counsel for the petitioner, submits that the writ petition has become infructuous. In view of above, the petition has disposed of as infructuous.
May I please, Your Lordship? Lordship, I'm taking consent from order side. I beg to mention item number 2. My lord, may we adjourn for a day only? Due to some personal difficulties of my senior, my lord.
Who is your senior?
I check here.
On the request made on behalf of Mr. I. Saikia, matter stands adjourned for the day.
May I please, Lordship? Lordship, I beg to mention item number 30, Lordship. Lordship, in this matter, we have filed an affidavit in reply, Lordship. So, Lordship, on Monday, Lordship. So, Lordship, may kindly allow us to bring the affidavit in reply on record today itself, Lordship.
Which case?
Pardon, Lordship.
Item number?
Item number 30.
You want to call the affidavit?
We have filed affidavit, Lordship.
When?
Affidavit on Monday, Lordship. 26th.
On 26th.
Yes, Lordship.
Can it be called? Yes, let it be called.
Oblige, Lordship.
May I please, Your Lordship? May I please, Your Lordship? Lordship, with the consent of the other side, Lordship, I beg to mention item number 25, Lordship. Lordship, in this matter, Lordship, we have received the instruction, Lordship. Lordship, if permit to like 4 weeks time.
I'm appearing for the petitioner, Your Lordship.
Any objection?
No objection.
Industries.
Yes,
Industries.
Lordship. Yes, Lord.
On the prayer of learned counsel for the Industries and Commerce Department, 4 weeks time is granted for filing counter affidavit. Interim order
Fine.
passed earlier shall continue till the next date of listing.
Oblige.
Please, Your Lordship. Mm. Your Lordship, I beg to mention item 33 of the Delhi list.
Item
Item
2,
33 of the Delhi list. I'm for respondent number 2 and I've taken consent from the petitioner.
23.
Yeah, no, 33.
Sorry,
33,
33.
33, yes.
What do you want? What do you want?
Hmm?
What do you want?
For respondent number 2, mention, I beg to mention.
What do you
item
want?
33.
What is your prayer?
That Your Lordship, this matter may be adjourned for today.
On the prayer made by learned counsel appearing for respondent number 2, matter stands adjourned for the day. All right.
Much obliged.
May it please, Your Lordship. Lordship,
Yes.
with the consent of the counsel for the petitioner, I beg to mention item number 4 and 7, Lordship. Here our affidavit is required, Lordship. So I pray for 2 weeks time, Lordship.
You have received instructions.
I have not yet received instruction because it was last listed on February 2023.
Item 4 and
And
item 7.
Lordship. I have taken the consent of the
Yes,
counsel
sir.
for the petition.
Elementary.
After 2 elementary, Lordship.
Elementary, is it?
Elementary, Lordship.
On the request of Mr. P. N. Sharma, learned training counsel, Elementary Education Department. Matter stands adjourned for 2 weeks to enable him to obtain instructions in the matter. Item 4 and item 7, same order.
For affidavit, my lord. For filing affidavit.
The learned counsel shall obtain instructions and file affidavit by the next date.
Oblige.
May I please, Your Lordship?
Yes.
I beg to mention item number 5, Lordship. Item number 5.
Oh, 5.
Yes, Lordship. Want to withdraw this matter, Lordship. The petitioner, as paid in the with the petition, he is relieved, Lordship.
Okay, what is your name?
D. Datta, Lordship.
Ms. D. Datta, learned counsel for the petitioner, submits that the petitioner has got the relief and therefore no longer wishes to press the writ petition. In view of above, writ petition stands disposed of as not pressed. Yes.
Lordship, I am appearing for the elementary education department.
Mr. P. N. Sharma, Learned Standing Counsel, appears for the Elementary Education Department. Yes. Yes.
Please, Your Lordship. As I follow the my lord, accidentally, I could not take the step. Today, itself I have been, I have prepared my lord. Today, itself I will take the steps. my lord.
15 to 20, is it?
Yes.
Steps on whom?
Respondent number, six, 15 to 20.
What is your good name?
MAI Hussain.
On the request of Mr. M.A.I. Hussain, Learned Counsel for the petitioner, 3 days' time is granted to take steps for service of notice upon respondent numbers 15 to 20. In terms of the court's order dated 19/2/2025. This is the matter again after 3 weeks.
Highly obliged.
May I be Lordship? Lordship, kindly come to the page 23, Lordship, paragraph 5. The order passed against which we are before your Lordship, my lord, not complied last.
Page 23.
Page 23, Lordship, paragraph 5, my lord. Kindly finish the order, Lordship. After, may I read it, Lordship? May I read out, Lordship?
Just a minute. Yes, read.
After careful reading on the affidavit in opposition of the respondent authorities, I am constrained to observe that there is no specific denial by them in the case of the petitioner. That though they were initially appointed as expeditionary teachers under the OBB scheme, the 600 posts from Nazia subdivision, including the posts held by the petitioners, are among the 2769 posts so converted into non-paying posts. The answering respondent also do not deny that the conversion of this post of the government issued the incumbency list under the authority of the Undersecretary of the government and that the incumbent having their names in the non-pen list approved by the government are acceptable for the release of salary. It is now the law of the pleadings applicable even to a writ petition that facts not specifically denied are deemed to have been admitted, and that admitted facts need not be proved. Under the circumstances, it is difficult to accept.
I think you come to page paragraph 6 straight away.
6, madam, the Lordship. For what has been stated in the following petition is allowed. The respondent authorities are directed to pay the current salaries of the petitioners within a period of 1 month from the date of receipt of the judgment. They shall also release the salary arrear of the petitioner within a period of 3 months from the date of receipt of this judgment. No cost.
Okay, so direction was
14.
to release the current salary within 1 month and area salaries within 3 months. Have you served a copy? What has happened? You have not been given.
No, madam. Nothing has been made.
Who is the respondent? Why is it pending for such a long time?
Long time, Lordship. Because
Why?
Lordship is aware, my lord, there cannot be exchange of pleading to ascertain the genuineness of the order already passed, my lord.
No,
for
that-
contempt proceedings also. Yes,
Those things I know. You tell me why it is pending for such a long time. The contempt of case of 2014.
Lordship.
Why?
Lordship, sometimes because of the pleadings, my lord, we have compelled to file pleadings. Reply.
No, just simple direction given. What pleadings?
Initially, it was under series, my lord.
Who is the respondent now? Concerned
Respondent,
respondent.
my lord.
Who is supposed to comply this order?
Education department, Lordship. Elementary education, Lordship.
Yes, you tell me the respondent number. So every time you are
Lordship.
impleading new respondents. Total, there are how many? 16 respondents now.
This Commissioner Secretary of the Government of Assam, my lord. Respondent number 1, the Commissioner and Secretary, the Government of Assam.
My,
My lord, all the respondents keep on changing. My lord, we have implemented the new incumbent also, my lord. The designation is Commissioner and Secretary, my lord.
who is the latest incumbent now?
Latest. Narayan Kumar, হচ্ছে। Narayan Kumar, no?
Narayan Kaur.
Narayan Kumar.
Is he impleaded as a party?
My lord, Commissioner and Secretary to the Government of Assam, my lord.
Is he impleaded as a party?
That's it. He's a party, my lord. He was party.
Respondent number, what
One.
is his? So who's the respondent?
Respondent number 1.
Mr. R. Modunda, he is on leg in court number 2 lawsuit, just for the time being lawsuit.
No, he's appearing for whom?
For the one, I think, one
This is a contempt.
is a contempt lawsuit.
So parties are rated by name
Yes.
and he will appear only by Vakalatnama, not as a standing counsel.
I think R. Modunda on last occasion.
He was only for
So who will appear? Your name is recorded also, Mr. Chisti.
Yeah, for the earlier commissioner lawsuit, who has been, I think,
Which respondent?
I have appeared for respondent 1, Pitom
Hmm.
on.
Lordship, only difficulty is, my lord, all the respondents keep on changing after 2-3 years, my lord. And we are filing different IM, my lord, for impleading the new incumbent, my lord. And last one is.
Respondent number 1, Mr. Chisti.
Yes, lawsuit.
No, he is appearing only for one respondent.
No. I'm for respondent 18 and 19, 18 and 19.
18, 19.
Huh?
Hmm?
18 is, that is wrongly shown, also 18 is finance. I think 19 is director of it.
So whom are you appearing for?
Item 19, director elementary. 18 is the secretary finance, that is I am not representing.
I'm asking you whom you are representing.
19 lordships,
I'm not asking you whom you are not representing.
19.
You appear for 19.
19.
19.
Suranjana Senapati.
Suranjana, so what have you done to comply with the court's direction? Are you still the director? Mr. Chisti?
Yes, sir.
Lordship, new income, my lord, Sri Narayan Kumar, the Commissioner and Secretary, my lord, now he is respondent number 24, my lord. So we used to file, my lord, impleadment petition, my lord.
So respondent number 24 is Mosina Nas.
No, lordship. We filed the impleadment petition, my lord, because they keep on changing, my lord, every after 2-3 years, my lord. So latest, my lord, we filed the impleadment petition, my lord. There, my lord, is 24, Narayan Kumar, the Commissioner and Secretary. Designation is sufficient, lordship. Commissioner and Secretary to the Government of Assam, Education Elementary Department.
I don't find any Narayan Kaur anywhere.
That is in IA, no? We
That
filed
I-
IA, my lord, to implement the new incumbent, my lord, because.
IA is a part of the main
Yes, yes.
contempt only. IA cannot be filed as it is by itself.
Amendment constitute was amended, my lord. Constitute was amended, my lord. Hmm? 25, lordship.
Hmm?
As per amended constitute, my lord, Narayan Kumar, Commissioner Secretary, CL number 25, my lord. Initially is in a different number, my lord, because keep on changing, my lord. We have 2-3 implementation petition file, my lord, because of the changes, my lord.
By which application did you implead Narayan Kaur? Tell me. IA number?
2154, lordship. 2023.
Then why the cost title doesn't show that? You have not taken steps
That is why.
to replace the cost title?
Services.
Steps, we have taken steps also.
No.
Yes, sir.
This is why it's pending. You see, you don't take steps.
No, Lordship, we have taken steps, man. We have already taken steps.
What I meant by taking steps was to get the name impleaded in the cost title by submitting the amended cost title. Mr. Counsel, look at me. Look at me. Why are you looking at him?
We have taken
I'm
steps.
speaking to you, you're looking at somewhere else. Mr. Counsel. See, you have impleaded somebody, some co-ops. That name is not available in the file. Only up till serial number 24. What you are supposed to do is, if your application is allowed, you are supposed to submit the amended cost title and change the name and incorporate the name, the new name.
Right,
That you have not done.
right.
Simply-
We have filed, Lordship.
Sorry,
Amended cost title, we have filed, man. We have.
where?
In file, Lordship, I don't know.
You
whether
take
we
the
have-
file, you show me, okay? You take the file, you show me who's the new person.
Lordship. Lordship is right, Lordship. We must amend, file the amendment cost title. man. But-
Mr. Majumdar, you are paying for anybody?
Paying for the earlier.
Which respondent number?
Respondent number 9, my lord.
9. So you tell me, what have you done to comply with the court's direction?
My lord,
See, the specific direction was to pay the current salary within 1 month and area salary within 3 months. That happened in 2014.
Yes,
And today in 2025,
there,
name after name has been impleaded in the respondents. Nothing is happening. What is this?
my lord, what has happened is there was a process where they had also participated to find out whether if they had actually worked and they were required to be regularized or whether they were illegal or irregular teachers.
Huh.
Pursuant to that, most of the petitioners have been offered appointment from the year 2022 onwards. And most of them have accepted it. Lordship would find one order, last order, if I'm not mistaken, my lord, where the court has recorded that petitioners were required to file the names who have already accepted the appointment, fresh appointments, foregoing all their past claims. Now, Lordship will give me a week or two. I'll also try to trace out whether all these persons have been appointed or not. I was under the impression that the information would come from them who have joined. Now, my lord, I'll try to take the information. This is not-
All of that, when somebody else is.
Let it be
petitioner
on,
has already
let it be 2
retired.
weeks hence, I will file that affidavit saying that all those persons who have participated in the process to give up their all past claims and join afresh, and who have actually joined afresh.
That you explain in an affidavit.
I'll do that.
I'll just say that you'll file an affidavit within a period of 2 weeks,
Will do.
explaining the manner in which the orders of the court have been complied with. You explain, we'll see.
And in other similar cases, for those persons who joined willingly, contempts have been closed.
Mr. R. Majumdar, learned counsel for respondent number 9, submits that he may be given 2 weeks' time to file an affidavit to show the manner in which the order of this court dated 4/4/2014 has been passed in WPC number 870 of 2012 has been complied with. Place the matter again on so and so. We'll give a date. Please file the affidavit and show what are the details, how you have complied with.
I'll
We'll
do.
see.
Obliged.
And Mr. Counsel, if you feel that there are new incumbents which needs to be incorporated, you take steps?
Yes.
Yes, next case.
There's one difficulty. The person that I represent has superannuated.
Hmm.
So unless the new incumbent comes in,
No, they'll take steps, but you file the affidavit to show what he has done. Is it not possible?
through him, yes.
You can also indicate that he has retired on so and so, but nevertheless, during his time, this is what had happened.
We'll do that.
And you also try to get hold of the new name, whoever is the thing.
Okay.
Otherwise, why should the court's order be flouted since 2014?
I understand that.
All right. You have to help the court
Definitely.
by bringing the particular person's name
Okay.
on record.
Okay.
Yes.
Obliged.
In this case, my lot, Lordship may kindly, my lot, take the item number 39, the writ petition first.
Yes.
My pillars. My lot, in this case, my lot, I have challenged the my lot, order of my lot amalgamation, that is my lot marja of my lot 21 number People Bari Part 4 LP School with my lot Uttor People Bari Bantimari Milan ME Madrasa. That is my lot, Lordship may my lot kindly first turn to my lot page 21 my lot.
Writ petition filed in 2018.
Yes, my lot.
There's no counter affidavit also.
No, my lot. In the my lot,
What is your challenge? What are you claiming?
my lot, we have challenged the my lot amalgamation order my lot.
Where is that amalgamation order? Page number?
Page my lot 27 my lot. It is type copy my lot.
27.
27.
Yes, 27. You're challenging this?
Challenge this order my lot. In pursuance of the government's office memorandum so and so, dated and subsequent approval so and so, the governor of Assam is pleased to amalgamate 61 those LP school with 52 UP, that is my lot upper primary schools of Dhubri district, and under the scheme of Shiksha Khetra. The details of schools are mentioned in Annexure 1. Then my lot, the Annexure is page 29 my lot. Our school has page my lot serial number 47. The
Just a minute. Amalgamate 61 LP school with
52 numbers of upper primary schools.
what do you mean by 61? This is the name of the LP school
No, my lord. Numbers of LP schools.
or numbers?
My lord.
61 numbers of LP
LP
school with 52 UP schools
52 numbers of
in
upper
Dhubri
primary.
district.
Yes, my lord.
Yes, and you are at serial number, your school?
Serial number 47, my lord.
47.
47. That is my lord. Uttor People Bari, Bangtimari, Milan ME Madrasa. It is the basic.
That is your school.
It is the base school. Our school is People Bari Part 4 LP school. This school, LP school, is amalgamated, proposed to be amalgamated with Milota People Bari, Uttar People Bari, Bangtimari, Milan ME Madrasa.
You belong to
Belong to Milota People Bari Part 4 LP school.
People Bari Part 4 LP school. You are from that.
It is for Milota column number Milota.
That is your school.
Yes, ma'am.
You are supposed to be amalgamated with.
Uttar People Bari, Bangtimari, Milan ME Madrasa.
Okay.
Then Milota, this order challenged Milota primarily on the ground that Milota, this itself is the violation of the government Milota notification dated Milota 22nd September 2016.
How?
It is Milota page 20 Milota because
How it is violated?
the school has to be Milota situated within the Milota same campus.
Same campus.
But
So
it
these
is
two schools are not the same
No,
campus.
in the same campus. It is Milota distance about 2 kilometers.
2 kilometers apart.
Yes, Milota. Page
So
page
now
39,
after amalgamation, the name will be Bangtimari.
Bangtimari.
Okay. So this has happened already.
No, my lord. It is the status quo order was passed, my lord, and so my lord, the school was existing in the earlier place.
So both schools are existing separately
Separately. Page 39, my lord.
by way of interim order.
By
So as per the, where is the guideline?
guideline page 20, my lord.
20.
20, my lord.
Yes.
My lord,
Serial number
serial number, my lord, 31, my lord.
31.
31.
31.
3, then my lord, close 1, my lord. Page 20, last paragraph, my lord.
Yes, read.
All the schools situated in the same campus shall be merged with the highest school.
No, where are you reading from?
Sapra 1, my lord.
Page number?
Page 20, 20, my lord.
Yes.
Sapra 1, all
Yes.
schools situated in the same campus shall be merged with the highest school. That is,
Hmm.
if there is higher secondary school in a campus, then other high school or ME or LP school or all the schools situated in the same campus, all other schools shall be amalgamated with the higher secondary school. Likewise, if the higher so and so, that is, the lower school has to be amalgamated with the
No,
highest school.
what do you mean by same campus?
Same campus, it is within the vicinity, nearby schools. Then page
Of course,
20,
because all the schools will be having their own different campus.
maybe, my lord.
How can it be same campus?
But, my lord, that is the guideline, my lord, page 22, my lord.
No, what is the meaning of definition of campus?
There is no, my lord, definition in the, my lord, notification, but, my lord, as far, my lord, Right to Education Act, the LP school, the two LP school has to be, my lord, distance between the two LP school has to be 1 kilometer. Within 1 kilometer, one LP school has to be, my lord, there.
So show me where is that kilometer thing here? Any
Well,
kilometer
page-
mentioned?
Page 22, my lord,
Huh?
page 22, my lord,
22?
Yeah.
Where?
page 22, my lord, serial number 12.
12.
If two or more LP schools are located within the radius of 1/2 kilometers, then these LP schools may be merged, provided that numbers of students do not exceed 100 in each school. LP school has to be merged or amalgamated.
Yours
if
is an LP school.
LP school.
So after merging, it should not exceed 100,
My lord.
or each school should not exceed 100.
Yes, my lord. After my lord, merge, it should be the student, my lord, minimum student should be, my lord, 100
After merging,
margin,
it should not exceed
exceed
100.
100. But, my lord, I am not, my lord, claiming that, my lord, student, since it is not marks and it is violation of, my lord, basic principles that, my lord, within same campus, and it has to be, my lord, 1/2 kilometers.
So campus would mean within 1/2 kilometer.
1/2 kilometer if it is a LP school.
Then for other schools,
Other schools, my lord, page 11, my lord, if two or more LP school, upper primary school,
Hmm.
it is, my lord, ME school,
1 kilometer.
1 kilometer.
So upper means 1 kilometer, lower is 1/2 kilometer,
1/2 kilometer. Then high school, my lord, serial number 9,
2 kilometers.
2 kilometers. That is why, my lord.
So depending on the standard, it goes,
Yes, ma'am.
increases.
Yes, ma'am. Then lordship may kindly turn to page 39, my lord.
So without verifying all these things, amalgamation was done.
Yeah, it was proposed to be done. Because, my lord, the amalgamation has to be.
Guidelines are there.
Yes, my lord.
So amalgamation, if it is to be done, then it has to go as per the guidelines.
Moreover,
So
my lord, the.
verification has to be done.
Yes, my lord.
Then only they will do that. So is it like that without verification, they are amalgamating the
Yes,
schools?
my lord, it was proposed to be, my lord, done.
Okay.
Then serial number 30, page 39, my lord.
39, what is this?
It is a report of the, my lord, BO, Block Elementary Education Officer, to the, my lord, District Elementary Education Officer, my lord.
Hmm.
In this case, my lord, paragraph 2, lordship kindly, my lord, peruse, my lord,
Hmm.
that, sir, the distance between the Peoplebury Part 4 LP school
2 kilometers.
and the upper so is 2 kilometers. And moreover, there is a crossing of a busy road to access the said ME Madrasa.
Who has written this? Block Elementary Education.
Block Elementary Officer to the, my lord, District Elementary Education.
So this has not been,
Not to be floating,
this has not been considered.
consider.
Yes,
May
Mr.
I please,
Sharma.
Lordship, regarding this merger and amalgamation,
Hmm.
there is a amalgamation merger re-verification committee has been constituted in 2022, Lordship.
Hmm.
So even in the memorandum also, that provision is there, Lordship, you will find
Yes, my lord.
19. Page number, Lordship.
So what
So
have they done?
There is a re-verification committee. Any grievance.
Committee is
that
there, then
Committee will decide. So Lordship may dispose of this writ petition with a direction to approach the re-verification committee. Lordship, I will place that, but fair copy is not there with me.
no, why they'll approach?
They should have approached. They did not approach yet.
Why they'll approach? You verify.
No, they have to they have to place their grievances, both the parties. Then
To whom?
that committee will.
To whom? Where is the constituted committee?
That constitution committee has been constituted under the chairmanship of the joint secretary to the government of Assam.
Where is
Department
that
of-
constitution?
Lordship?
You have not even filed the affidavit.
No, not yet filed.
Where is the constitution?
It is there, Lordship. The copy is there. The fair copy is not there. The my copy, I'm just placing. I will place the fair copy, Lordship. Even my learned friend is also agreeable to this position. So they will verify, the committee will verify.
When was this constituted?
It was in 2022, Lordship.
Is it still there?
This lordship.
Are you sure? This is by name.
Otherwise,
S.N. Das, Joint Secretary,
lordship.
Anjala Bhuyan, Deputy Secretary. They may have been promoted, retired, whatever, transferred. We don't know.
It was in 2020.
This is not a,
Although that update.
this is not a standing committee.
Otherwise, I will confirm it, lordship,
Hmm.
whether that, but to my instruction as of now, although I have not updated the thing, but there is a committee. There is a committee.
If there's a committee, well and good, but tell me, who will be the respondent here? Concerned?
Lordship will,
Director.
kindly come to page number 22,
No. We have understood what the problem is.
lordship.
There's a dispute regarding the distance and all that.
Okay.
So we'll direct the Director of Elementary Education to
Lordship,
examine this aspect,
lordship,
and if there's a standing committee,
lordship.
to place it before the committee for
Lordship.
verification.
Lordship. And now I will assert that this committee is still in existence. Lordship, that will prove from the, you lordship may kindly come to page number 22. In the office memorandum, there is a clause. Clause 5, page number 22. There shall be one committee at the block level and district level to find out the schools which are eligible for amalgamation, mergers in view of the provisions of right to so and so, not less than by so and so.
Page 22,
Lordship,
serial number.
clause 5. And page number 23, clause 7. Page number 23, clause 7. The director consult, may I read, lordship?
Read.
Page number 23, clause 7. The director concerned will issue necessary order for amalgamation. For any dispute arising out of the order, the aggrieved institution or public may prefer an appeal before the government in the secondary or elementary education department, as the case may be. Therefore, they will prefer an appeal before the secretary. This provision is there in the OM.
See, at any rate, before amalgamation,
Lordship.
did they not have any verification?
They did have, but they may have, the concerned parties may have grievances. So for the redressal of their grievances.
No, I'm not asking about that.
Lordship.
I'm asking you regarding,
No, after
This,
due verification that.
listen, please listen.
Lordship.
This notification says that 61 schools, 52 schools,
Lordship.
whatever,
Lordship.
are being amalgamated.
Lordship.
List is given. Prior to the amalgamating these schools, did
Lordship.
you not have any verification?
Lordship, with due verification that amalgamation has taken place.
Huh?
But despite that.
Where is that?
That mention is not there, lordship. Otherwise, I will file affidavit, lordship. But
No.
they can prefer an appeal before the secretary.
You have not filed affidavit since 2018. How will you file now?
It was perhaps last listed on.
Another 5-10 years will go.
The matter maybe will have to refer to the director, they will verify.
Exactly, that's what we're going to do.
Lordship, instead of perhaps director, according to the amount, the secretary to the Department of.
Director will initiate and give it to the secretary. Let him collect the materials and give it to the secretary.
Lordship.
Status quo was given by which order?
By it is first 12/11/2018 in the revision
12/11/2018. Review, taking stay one.
না রিভিউ তো হচ্ছে রিভিউ তো হচ্ছে
Continue করিস।
হ্যাঁ
না review এটু order stay করিস লাগে।
এইটু অর্ডার হয় এইট সেম অর্ডার টু রিভিউ
Okay, please write down. What is your good name?
and the review is that because when we approach this honorable court and the stay order was granted, then we came to learn that the amalgamation order was has to be effect. Then one Shamsher Ali was filed a writ petition, and he obtained a order on the motion day, suppressing all these material facts without enclosing the government notification. Then
No, what did he obtain?
when we obtain the interim order in the writ petition,
Yes.
then we came to learn that another party,
Hmm.
he approved this honorable court,
Hmm.
he obtained an order to give effect of the impugn to amalgamation order.
Okay.
Then we approach we file the review
Ah.
petition.
Ah.
Then in the review petition, orders 23/1/2019.
Which order you are seeking review? Let us see the review petition.
That is page in the review petition page 48.
48.
48.
Given by the order.
12. The part page 49.
Or for affecting the merger.
Yes, to give effect of the merger. So we
Okay.
file the review petition. Since we challenge in the writ petition, and we obtain the interim order, not to restrain the respondents. Then since it is a order of giving effect of the merger order.
Any order passed in this review
Yes,
petition?
that is first order was passed on 23/1/2019.
Yes, what is that?
The earlier interim order passed in the writ petition, that will be continued. In the meantime, the interim order dated so and so passed in WBC number so and so shall continue. 23/1/2019.
Okay, so the person who came before the court was different person,
Yes, third party.
but pertaining to the same school.
No, he is the president of the upper primary school.
Another school,
Yes,
not your school.
No, my school. He is the president of the
So
MA school.
he should have prayed for giving effective of the amalgamation in respect of his school,
These two schools. Because
not your school, isn't it?
no, my lord. He is the president of the MA school. We are the parents of the LP school. These two schools have to be amalgamated.
Amalgamated.
Or your schools are to be
Yes,
amalgamated.
two schools.
Oh,
MA school, LP school with MA school.
okay, then what happened to this writ petition? It was disposed of.
No, not disposal. So both the matter has been connected.
Pending.
It was disposed of, Mr. Counsel. What are you saying?
Yes, my lord. Their writ petition was disposed of.
That's why you sought review of that order.
Yes, my lord. That was disposed of by order dated 12/10/2018.
Anyone appeared on that for the other side in this review?
Their name has been shown.
Then the super after all this stuff. And perhaps on the last three occasions they sought time.
Yes.
Hmm.
On the last three occasions, I have seen that they have sought time.
This is item number
38 and 39.
38 and 39. Please write in item 39 first. You are Mr.
DA Kayyum.
Heard Mr. D.A. Kayyum, learned counsel for the petitioners, who submits that by filing this writ petition, the petitioners have challenged the notification dated 26/6/2018, bracket annexure 3, by which you people,
Uttar people bari.
where is that written?
I have given paragraph 4
It's okay. I'm reading only what is written here, okay?
Yes,
I'll ask you if I require any assistance, I'll ask you. Please don't interrupt. By which you people Bari, Banki Mari, Milan, MEM has been sought to be amalgamated with People Bari, Part Roman 4, LP School. In violation of the standing guidelines issued by the Government of Assam in the Secondary Education Department, White Office Memorandum dated 22/9/2016. Stop. The Learned Counsel submits that the petitioners belong to People Bari, Part Roman 4, LP School, and that as per the guidelines, more particularly paragraph number 3, bracket 12, comma, if two or more LP schools are located within the radius of half kilometer, then the LP schools may be merged, provided that the numbers of students do not exceed 100 in each school. Stop. The Learned Counsel submits that the two schools sought to be merged are 2 kilometers apart and cannot be merged together in view of the guidelines. Stop. The Learned Counsel submits that this fact has also been informed by the Block Elementary Education Officer in charge, Mankacha, to the Deputy Inspector of Schools, South Salmara, Mankachar, White communication dated 30/10/2018. Stop. Despite the same, no steps have been taken not to amalgamate the two schools in question. Stop. Having no alternative, the petitioners are before this court. Stop. Next para. The Learned Counsel submits that this court, while issuing notice of motion, on 12/11/2018, was restrained from merging the petitioner school with that of Uttar People Bari, Banki Mari, Milan ME Madrasa, and the said interim order continues till date. To stop, the Learned Counsel submits that Mr. Counsel, who is that person who had come to this court? for
Yes, madam. He was the president.
affecting the amalgamation?
He was the president.
No, by what application? He filed separate writ petition.
Yes, yes.
What is the number?
Yeah, that is 7354, madam. Page 48.
Huh?
Page 48 in the review petition, madam.
48.
Page 48 in the review petition.
48.
48.
Who is he?
But he was the president
Of
of
the
the
SMC. President of the SMC, madam. School managing committee, madam.
Okay.
people bari Bangtimari and Madrasa.
Is a member.
Member.
President, my lord.
President.
Gustav, the learned counsel submits that while the same was the situation, the president of the school managing committee approached this court by filing WPC number 7354 of 2018. Seeking enforcement of the amalgamation notification. And this court, via order dated 12/10/2018, directed the respondents to take all necessary action to effect the merger of the schools at the earliest.
Headmaster, my lord, already hand over the charge. Amalgamation by virtue of the order, my lord, notice was issued to the.
Now, what has happened? There's a stay order, isn't it?
Yes, my lord.
There's a stay order.
For communicating the stay order, my lord, already order was passed and merger was completed.
Merger is complete. How is it complete?
The order.
No, the review is here. Review has says that interim order passed on so and so will continue. So if it's complete, it is wrong.
But the headmaster hand over the charge. It is there is a
As per the earlier order, my lord.
but since the headmaster of the LP school, our school was interested to amalgamate with the ME Madrasa. So my lord, at the verse of his retirement, he hand over the charge to the my lord, headmaster of the my lord, ME Madrasa.
So what is happening as on today?
But as on date, my lord, both the schools my lord, situated separately in the earlier place, my lord, no merger has been given effect.
Okay.
My lord,
As on date. my lord.
I am the headmaster, my lord. As per
Oh,
order
headmaster of which school?
of that school.
Which school? There are two schools. Which school?
My lord, the LP school, my lordship, which has been merged with the ME school, my lordship.
You are the headmaster of
LP school, that is the people.
LP school.
Yes, my lordship.
Okay. So your school is still functioning separately, isn't it?
My lordship, I have, in the meantime, what happened, my lordship, when the Honorable High Court passed the earlier order, in compliance with the earlier order, I got direction from the department to hand over my charge as
Yes.
headmaster, my lordship.
Then?
In pursuant of that direction by the Honorable High Court and the department, my lordship, I handed over the charge, my lordship. And after that, I have already retired, my lord. That's all I have to say, my lordship.
Okay.
And my retirement, I have already retired.
Okay, I've understood. Anything else? Nothing more?
Nothing.
Okay, enough. Then
He is fairly submitted. my lord.
Okay.
Because the school is my lord, submitted.
Then pursuant to the, please continue. Pursuant to the said order dated 12/10/2018, the headmaster of the People Bari Part 4 LP School handed over charge to whom?
My lord, the headmaster of the ME school, my lordship. Because I became assistant teacher, my lordship, after merger.
To the headmaster of the ME school. That is you, People Bari, Bangti Mari, Milan, MEM. and subsequently has retired.
Yes, sir.
Stop. However, the instant writ petitioner filed review petition number 194 of 2015.
After the merger has been completed, my lordship, they filed the petition. It was infructuous at that moment of time, my lordship.
Seeking review of the order dated 12/10/2018, passed in WPC number 7354 of 2018. Full stop. This court, white order dated 23/1/2019, in review petition number 194 of 2015, while issuing notice, directed that the interim order dated 12/11/2018, passed in WPC number 7702/2018, shall continue. Stop. It is submitted at the bar that both the schools are functioning separately as on date. Next para. It is seen that the respondent respondents, as per the office memorandum dated 22/9/2016, clause 5 first, isn't it?
Clause 7, Lord, page number 23.
More particularly at clause 7. Comma, it has been provided that the director concerned will issue necessary order for amalgamation. Stop. However, for any disputes arising out of the order, comma, the aggrieved institution, public may prefer appeal before the government in the secondary or elementary education department, as the case may be. Stop. He submits that since the petitioners have raised a dispute by taking the stand that the amalgamation directed is not in conformity with the guidelines set out in the office memorandum dated 22/9/2016. Comma, the petitioners may approach the state government in the elementary education department
School education, my lordship.
for redressal of their dispute. To stop. Next, but I have considered the submissions made by the learned counsels for the parties. To stop. The office memorandum dated 22/9/2016 at clause 3 bracket 12 clearly provides that if two or more LP schools are located within the radius of half kilometer, then the LP schools may be merged provided that the number of students do not exceed 100 in each school. Stop, according to the petitioners, the distance between the two schools is 2 kilometers. And therefore, merger of the schools cannot be done. To stop, this aspect of the matter was also brought to the notice of the Deputy Inspector of Schools, South Salmara, Mankacha, by the Block Elementary Education Officer in charge, Mankacha. Write his letter dated 30/10/2018. Stop, such being the position, the director of elementary education, Assam, what is to be done? Mr. Sharma?
Direct the petition parties to approach the.
Approach, my lord. Because there is a land
In
dispute
fact, yes,
regarding the.
They have to approach the secretary to the Department of School
Yes, my
Education,
lord.
placing their grievance.
What was the last sentence? Such being the position, is it? What did I say? Okay. No. The director from the Encadrement, such being the position, the rest you cut. The petitioners shall submit a concise representation before the director, Elementary Education Department, Government of Assam, within a period of 15 days.
13 1 month.
Why?
Because my lord, they have, my lord, I have to inform them, my lord, they have to.
Within a period of 1 month from today. Clearly expressing the grievances with regard to the amalgamation of the two schools, while submitting supporting documents, and the director within a shall on receipt of the same shall place the matter before the state government for consideration. To stop, it is also provided herein that if there is an amalgamation merger re-verification committee in existence, the said committee may consider the grievances projected by the petitioners.
My lord, my one submission may be
By
report.
taking into account the guidelines provided by the office memorandum dated 22/9/2016. Stop, such consideration should be done as expeditiously as possible and within the outer limit of 2 months from the date of receipt of the representation.
Yes, ma'am. One submission may be
Yes.
granted, my lordship. The land of the school, my lordship, I have donated land of the school. And, but as it was a low-lying area, I used to teach in my house courtyard, my lordship.
Hmm.
So the permanent school, my lordship, I don't have any objection. If the school is, if it is amalgamated or not amalgamated, my lordship, it should be built in the particular land where I have donated, my lordship. Now it is in the courtyard of my home, my lordship. And my sons have also, children have also grown up, my lordship. And this is the reason why that school was amalgamated, because there is a problem in road connection.
Anyway, you
The
project the
government
same,
to original
you
position.
project the same before the committee concerned. They will take into consideration.
The school is in my courtyard only.
Maybe.
Because.
We are not
it is
deciding
my
anything. We are
lordship.
referring the matter to the committee. So you may represent also before the committee if you want to. It's up to you.
And current status, my lordship.
Stop. It is further provided herein that till such decision is taken by the government or the Amalgamation Merger Reverification Committee, the interim order passed. The order of status quo
Yes, Mr.
passed. White order dated. The status quo passed, the order of status quo passed on, what is the date? 12/11/2018 shall continue.
Published.
Now what will happen to the review?
Then the review may not in view of the petition sort out, that may be closed.
Review separately. In view of the order passed today in WPC number 7702 of 2018. The review petition also stands disposed of in terms of the said order.
Highly obliged.
All right. Continue.
May I please, your lordship? This is a contempt case of 2018.
Hmm.
And my one fact is important there, the common judgment was passed in 3 writ petitions. And I, in my writ petition preferred this contempt case. Other 2 petitioners in the other 2 cases has been already given the benefit. But as because I prefer this contempt case, my benefit is yet not been considered till date. And on the last occasion, instruction was sought for my lord. Respondent.
What is the order which is to be complied with? Show me that first.
My lord, page number 43 is the relevant portion of the order against which the contempt case is preferred.
Writ petition was what?
For regular effective date of regularization, my lord.
No, this was a common judgment.
Yes,
How many writ petitions? 3.
3, yes.
Okay.
First number is 476 of the 2023,
You're concerned with which number?
6262 of the 13.
6262,
Yes, of the 13.
2013.
Yes.
Okay. And the order dated is 29/5. 2017.
My lord, this is the order
Yes, what
passed
is,
by the department where other incumbent has been already given the benefit.
let us first understand your case.
Well.
Where's the operative portion?
As 43 miles.
Hmm.
42, paragraph 23 is the operative portion. The only thing is whether it will be under OPS or new pension scheme. Page 42, paragraph 23.
Please read.
Further, the other issue as to whether the petitioner will come within the purview of Assam Services Pension Rules 1969, or their cases would be covered by the new pension scheme 2005. Under the Assam Service Pension Rules 1969, if the petitioners met the requirement of the last qualifying services, they are entitled to regular pension as provided under the said rules. Whereas under the new pension scheme, which has been made effective from 2005, any person appointed regularized from the said dated 1st of February 2005 would be covered by the new pension scheme of 2005. Well, this is the main crux of the whole writ petition. And direction is, my lord, at page paragraph 25.
So old pension or new pension?
Yes,
Either it should be old pension or new pension.
yes.
So who will decide?
The commissioner.
Commissioner?
Paragraph 25. Commissioner and secretary, presently the respondent number 6. Earlier respondent number 1 already retired.
So that was the only thing to be done.
Yes.
To decide whether you're covered by the new pension or the old pension.
Yes. And
Then what is this?
this is the order passed in the year 2022, where the other two incumbents of the other two writ petitions, where the common order was passed, that has been given the benefit.
What
of
benefit? Which benefit?
Old pension.
Old pension.
Yes,
So which one do you want? Old or new?
old. Because in
You want old
Yes,
because it's beneficial. New is contributory.
yes.
But court has not said that you give them old. Court said they decide. That's all.
But that decision is not yet done.
Yes, Mr. Bora, why can't you decide?
I am here only because of my lord, for respondent number 3. On
Who is
telephone-
respondent number 3?
Respondent number 3 is secretary of the SCRT. So the petitioner sign.
Who will decide?
My lord, the commissioner will decide. But why I am.
Commissioner, who? Which commissioner?
Secretary, Education Department. will-
Finance.
No, no. Education.
Finance.
Education Department. No, I am here because the earlier incumbent, today I've done telephoning instructions. I am here, my lord. I have not filed my power, my lord, Ukalatnama, my lord. I am here because the earlier incumbent who filed the affidavit on behalf of the SCRT, direct to SCRT, here we don't use Ukalatnama. On telephoning instructions, I am appearing here. Already our affidavit had been filed. Affidavit says that there is a report also in the last page of the affidavit, my lord, that these persons are going to get pension as per the new pension scheme. We have filed a
Where is that? Where is that?
My lord, it's a part of the record, my lord. There is a affidavit even filed by respondent number 3, my lord.
Where?
I have gone through the record, my lord. No, I don't have the petition, I have been telephoning instructed to API, my lord.
Show me.
This is filed by,
Mr. Counsel for the petitioner, you see, court has not said that you give him this or you give him that. Court merely say that you decide which one is to be given.
Yes. But
Some of them have been given all pension. But in your case, Mr. Bora says you have been given new pension.
there is to be a specific reason for giving then and denying me. But denial is not yet been done. That is one also for which I am not in a position to challenge it.
Which one?
my lord,
Mr. Bora?
yes, that A, it is written flag mark pink color, my lord, affidavit filed by Niroda Devi, my lord. He is the director of SCRT, my lord.
Hmm?
Lordship will see the page number 6, the last page, the next 3.
Six.
A report has been prepared, my lord, going through all the
Inquiry report.
inquiry report, they are from them. May I read it, my lord?
Yes.
Compliance with the order issued memo number so and so dated 28/2019. The inquiry committee has gone through the documents along with its record relating to ad hoc appointment of 32 numbers of non-gazetted employee and made during the period 1999-97 in Defense Institute of the Directorate of SCRT and found that in the interest of the functioning of the institute, the employee concerned has initially been appointed ad hoc basis for a period of 4 months without producing any advertisement and selection. The ad hoc service were extended from time to time for the smooth running of the institution. In pursuance of government letter number so and so dated 17/5/2010, the service of the subsequent been regularized with effect from 27/9/2007. Since 2007 it has been regularized, the NPS has come from 1st of February 2005. And the new pension rule 2005, white office order issued number so and so, dated so and so, they will come under the new pension scheme.
And this point has been already discussed by the board, my lord. Because my
Our
We are-
duty is to examine, my lord.
Anyway, we are concerned about the compliance on,
yes.
that's all.
my lord, may I place another two communication between the departments? They are now saying that the old pension OPS will be given to the employee who were.
Just a minute, just a minute.
Yes.
Mr. Bora, this inquiry report is there. Now, where is the order passed? Decide. They cannot be given, they can be given or whatever.
That is to be passed by the secretary.
Lordship will fi-
Pass the order. If they're not unhappy about that, they'll challenge it by filing the appropriate application.
well, that may not, that may be, I will take
You
the.
are representing whom?
I am representing respondent number 3.
Who is that?
He
Respondent
is the
three?
director of the SCRT.
Director, okay. Now, who will pass the order?
Ultimately, inquiry report will be sent to the commissioner secretary. He'll go through it and.
No, why don't you send the inquiry report
My
to
lord,
the secretary?
my lord, Lordship will see. Lordship will,
What is stopping you from sending the report?
that instruction I will get, whether this report, instruction has been sent or not, my lord.
In the meantime, some further development has been already on.
See, Mr. Counsel, don't stretch this contempt petition like that. Since 2018, it's pending like that. Every time,
My lord, my lordship will turn to page number 2, my lord, of my affidavit, paragraph number 4.
what is the paragraph number 2?
Paragraph 4, it has been sent to the commissioner secretary, my lord. While later dated 15/5/2018 and 13/6/2018.
Page number?
Page number 2, my lord, paragraph number 4.
Page number 2 of what?
Of the my affidavit, my lord.
That same affidavit.
Same affidavit, my lord. Deponent beg to submit that in compliance of the Honorable High Court order dated 29/5/2017, the office of the deponent has verified the record. Thereafter, and the commissioner elementary department has been requested to file letter dated 15/5/2018 and 13/6/2018 for instruction, but no instruction has yet been received from the on the issuance in hand, on the issue in hand.
Yes, Commissioner. Who's for the Commissioner?
Now, at that particular point of time, it was commissioner, now it is
Secretary, my lord.
Now
Respondent number 6, Narayanpur.
Hmm?
Newly
Respondent number
created.
6.
Yes. Earlier, respondent number 1 was there. He retired, so now the present incumbent is respondent number 6, Narayanpur.
Is he still there?
Yes.
Yes.
On the
Who's
last
appearing
notice
for
of
him?
register-
yes, recently been
If I had filed
implemented.
my call number lawsuit, but I have requested my friend to appear to file an ukalma on behalf of present secretary because it is in SCRT department lawsuit, so it is difficult for lawsuit, man, he will represent lawsuit.
But I don't have the power. Even respondent number 3 also, I don't have it. to take
Mr.
the-
Chisti,
Yes.
you appear for the Commissioner Secretary.
Yes.
See, you have to take steps. Because one paragraph has been shown here. The deponent, that means the NCRT,
SCRT.
wide
Yes.
SCRT, wide letter dated 4/5/2019 has forwarded the said report to the Commissioner, Elementary Education Department for information necessary action. 3-member committee, they made some a report, has been forwarded to the Secretary. So let the Secretary decide. If they are not entitled, say so,
Yes, yes.
so that whatever remedy is available to them, they can go for that. You cannot keep it hanging like that. But this affidavit was filed long time back,
It's a very long time.
2019.
And the council who have filed, he has withdrawn his ukalma also in this case. That's why. also
21/2019.
The present standing council, they are not aware of this lawsuit.
Today on telephonic instruction, I am saying.
But you as the secretary, you should be aware of this, isn't it? Because they say that it was communicated to you.
It was the earlier, in the 2019 lawsuit that earlier commissioner was there lawsuit. And anyway, lawsuit, I will inform the present secretary. Because he implemented later on.
Mr. SMT Chisti, learned counsel appearing for respondent number 6, submits that he may be given some time to obtain instructions as to what steps has been taken by the government on the inquiry report submitted by the 3-member inquiry committee. What is the date? There's no date.
Well, date of filing.
No, on page number 6, the report
No, there is no date, my lord. I have gone through it, but there is no date.
dated nil, which was said to have been forwarded by the SCRT.
SCRT, this is a.
Which
inquiry
authority in
committee.
SCRT?
SCRT, but committee,
Who in the SCRT? Any authority?
yes, director, SCRT.
Who was said to be forwarded by the director SCRT to the Commissioner
Education.
Elementary Education Department on 4/5/2019 for information and necessary action. As reflected in the affidavit of Srimati Nirada Devi, bracket respondent number 3, filed on 20/6/2019. Stop. Let the matter be listed again on so and so. When can you get the instruction? Mr. Chisti, give a date after 2 weeks.
13. 13. Then I get to- May I pay for another date, my lord? 15 or 16? 17. Obliged.
Mr. Chisti.
Yes.
So the report is forwarded to you. Now you just have to pass some order.
Ignore, I will inspect it.
yes.
Definitely, Lord.
Obliged.
I'm not pressing this matter, Lordship.
Hmm?
I'm not pressing this matter, Lordship.
Okay, Mr. M. Khan, learned counsel for the petitioner, submits that he has instructions not to press the matter. In view of above, the petition stands disposed of as not pressed. Mr. P.N. Sharma, learned standing counsel, elementary education, APS for the elementary education department.
Okay.
Yes.
Here I have received it.
What is this?
No, it's a contempt petition, my lord. The
Compliant. Compliance.
Not compliance, my lord.
Then what are you passing on?
What's compliance?
No,
It's a.
why do you bring such kind of papers like that and pass it on to the court? This is not the way.
Or my lord, I can file an affidavit to bring on record, my lord.
What is it about? What does it say?
This is regarding, my lord, her case was considered and now it will be placed before the cabinet, my lord.
When was it considered?
My lord.
What is this compassionate appointment?
No, my lord. The similarly situated people are getting regular pay scale. I'm only getting 15.5K, my lord. 15,500
As what?
as monthly salary, my lord.
As in the post of
Teacher. Assistant teacher, my lord.
assistant teacher.
Yes, my lord.
What is the direction of the court? Let's see.
My lord,
Page-
this is page number 8, my lord.
8.
Page number 8, my lord. Yeah, read, my lord.
Yes.
Yes, my lord. Para 2, the claim of the petitioner related to the benefit of regular pay, which according to the petitioner, they are entitled to in the view of the decision of this court rendered in WPC 763/2013 on 16/12/2016, which was affirmed by the division bench of this court in the writ appeal 233/2017 on 14/6/2019. It has been submitted that the petitioner was initially appointed assistant teacher after going through regular process of recruitment on the basis of advertisement and recommendation made by the competent selection committee in Dholega Higher Secondary School.
All right, Mr. Counsel, I got it. See, how much time?
2 weeks, my lord.
We'll fix a date.
Yes, ma'am.
You please come back with the proper instruction.
Yes, my lord.
Your good name?
E.W. Aman,
Mr. A.W. Aman,
my lord.
learned counsel appears for the petitioner. And Mr. N.J. Khatania, learned counsel appears for respondent number
1, my lord.
1. And he submits that the process of complying of the court's direction is on. And prays for further 2 weeks' time.
A date may be fixed.
Stop. Stop this court by order dated 19/7/2019 in WPC number 4808/2019. More particularly at paragraph number 3 of the said order that directed the respondents to examine the claim of the petitioner for grant of regular pay similar to those given to others, similar to the one given to others. Since Mr. N.J. Khatania, Learned Counsel, submits that the process is on, 2 weeks' time is granted as paid for. To inform the court about the status of such consideration. List the matter again on so and so.
Oblige Lordship. Grateful, my lord.
Yes.
My lord, we are seeking review.
Of which
No.
order?
Order dated 21/6/2019 at page 66 will find the lordship.
66.
Of the review petition. Lordship will straight away come to page 69. The last page of the review.
Yes.
May I read it, my lord?
Yes.
Heard Ms. So-and-so, Learned Counsel for the petitioner. Also heard Mr. A. Roy, Learned Standing Counsel, PNRD, and so-and-so, but Learned Government Advocate. The grievance of the petitioners is about non-payment of their monthly remunerations. The petitioner number 1 is the elected president, the petitioner number 2, the elected vice president, and the petitioner number 3 to 8 members of the 2 number of Abhapur, Gram Panchayat under Sonari and Salik Panchayat under Saraidev subdivision. The petitioners were elected as the president and vice president of the members respectively on 15/12/2013, and they rendered their services in the aforesaid capacity till completion of the term of 5 years. The Learned Counsel for the petitioner submits that all the petitioners have received their salaries only for 19 months, and for the remaining 41 months, they have not been paid their salaries, remunerations, so and so per month respectively. Now, this is the impugned parameter, para 3. In view of the above, the present petition is disposed of with a direction to the respondent authorities, more particularly to the respondent number 4 and 6. Respondent number 4 is the Deputy Commissioner, Saraidev District, and 6 is the Block Development Officer, to verify the claim of the petitioner and release the area monthly salaries remunerations for the period they have not been paid. This exercise shall be undertaken by the respondent authority within a period of 3 months from the date of receipt of a certified copy of this order.
So what is there to review?
Yes. Now, my lord, up to verification, there is no difficulty. But the direction to release the salaries, my lord, is beyond the rules, my lord. It's contrary to the statutory prescription, my lord. Because the rules governing, by the Lordship, I quoted the rule, Lordship will take the book also. Rules provide that.
Where have you quoted?
I've quoted, my lord, at
Page?
page number. Page number 7, page number 8, my lord, of the review petition.
What is the name of the rules?
The Assam Panchayat Administrative Rules 1995, Rule 15.
So they say that some remuneration is pending.
No.
Court said that you verify and pay them.
But
What is wrong in that?
verification, no problem, my lord.
Who will pay them?
My lord, they have to, let you kindly go to the rules. It is from their own sources. Let you read this.
Then what is the fun of having verification if there's no payment?
In fact, verification is also not required because they're elected members, my lord. Verification is also not required. They contest the election, Panchayat election, and they're elected members. As per section 12(2) of the Assam Panchayat Act 1994.
See, you were represented by your standing counsel.
No, this was disposed of on the very first day. No notice was issued, my lord.
I understand, but
But this
you are
pro-
represented by your counsel.
Absolutely true. I am not disputing.
Your standing counsel will know what is what.
Absolutely true. I am not disputing, but this rule was not taken into consideration. The payment has to be made, my lord, from their
From their own
source-
resource.
own resource.
That is the simple
Yes, that
issue involved.
that has to be reviewed.
That is the only and simple issue involved. Yes, what do you say?
Yes, my lord, I am on behalf of the respondents, my lord.
Ah,
I'm agree to that action, my lord, with my learned friend.
ah.
At least they have verified these things. And of course, the disbursement authority is the Panchayat itself, the secretary and but verification is to be done by the deputy, whether we have rendered our service during that period or not,
Verification not done.
not done. That's
Do
why,
you verify then?
yes, yes.
No, madam, Lordship will review this order. They will obtain a certificate, copy, file a fresh revision, officers will verify, my lord. But this has to go, man. They should review, modify.
You are referring to which laws or section or rules? Rules 15.
Rule 15 provides that it has to be from their own sources. Lordship can take this book, my lord. And this honorable court, taking note of this rule, has stayed the impugned order by the order dated, my lord, 8/5/2023. Lordship can peruse that order. Because on the strength of this order, they filed a contempt petition.
So if you agree, we can dispose it off.
Yes, yes.
Yes, madam, to that extent, my lord. They will verify
Verification they're done, then thereafter what will happen?
that they will send to the Panchayat concern and they'll Panchayat concern pay us from the devolution fund.
Oh, you are not along, you are not you're not in the Panchayat now.
No, we are, our
Currently-
term is over. my lord.
You were the previous employees.
Yes, yes, previous.
Actually, the direction ought to have been to the Panchayat and Rural Development Department.
This is Assam Panchayat Administrative Rules 2002.
True, yes, I have the book, my lord, if you're not.
It's okay. Please write down. Heard Mr. J. Patowari, learned counsel for the review petitioner, and Mr.
H. Rahman,
H.
yes.
Rahman, learned counsel for the respondent.
All the 8 respondents.
All the respondents.
For the respondents. Stop by filing this review petition. How many petitioner?
Well, 2.
Two only.
The petitioners, by filing this review petition, the petitioners have sought review of the order dated 21/6/2019, passed in WPC number 4243 of 2019. To stop, Mr. J. Patowari, learned counsel, by referring to the said order, submits that this court had directed the respondent authorities, more particularly the respondent numbers 4 and 6.
That is the review petitioners.
Who are they, 4 and 6?
Deputy Commissioner is.
That is the Deputy Commissioner and the Block Development Officer,
Saraidev
Charaidio
District.
District, to verify the claim of the petitioners in respect of the non-payment of salaries / remuneration. And upon such verification, if it was found that amount has not been given to them, to release the same to the writ petitioners. So stop referring to Rule 15 of the Assam Panchayat bracket administrative close bracket Rules 2002. Mr. J. Patowari submits that the remuneration of non-officials of Gaon Panchayat and also the sitting allowances of the members are to be met from their own resources. Stop, such being the position.
My lord, one thing I point out. That own resources have been modified now, 2012, that is at page 51 of the review petition. From the devolution fund, my lord.
No, both are there.
Both are
Page
there.
53,
Page 50,
Rule 15 has been amended at page 53. of the-
page 53 is a relevant portion.
Now the devolution fund has been brought in addition to own resources.
Yes.
This will be applicable to you also?
No,
Now?
no, it will be applicable to the government. I am the deputy commissioner.
No, I'm sorry, no, to this case, I mean.
Yes, yes, it is.
Uh,
12, so it is applicable. Amendment rule 15, that is page 53, my lord.
which part?
Page 53, my lord, may I read?
Mm.
In the principal rule on rule 15. in
No, that
sub-rule-
devolution part, you just show me that.
Yes.
Down below, sub-rule 3, my lord. So, out of the devolution fund of the Gaon Panchayat and the Gaon Panchayat own resources.
Yes,
Last
both.
last three lines at sub-rule 3, Roman 3.
Both are there.
What did I say? Before that? On resource, like. On resources and also devolution of fund. Stop, then read. Such being the position, the learned counsel submits that the order dated 21/6/2019, insofar as the direction has been made to the respondent authorities for payment of the salaries oblique remuneration, may be recalled, since the same is
In violation.
not in conformity with the rules of 2002. Rules of 2002 thi mera bracket hai. Mr.
H. Rahman,
H. Rahman, learned counsel for the
respondents.
respondents, submits that the respondent authorities, no, submits that uh, the direction for verifying the amount payable to the writ petitioners, writ petitioners may not be interfered with, but insofar as the direction for payment of the amount due by the Deputy Commissioner and Block Development Officer, Charadio District, may be recalled. He, however, submits that the amount, so after such verification is made, the amount so found to be due should be forwarded to
Concerned Gaon Panchayat.
concerned Gaon Panchayat for payment in terms of Rule 15 of the rules of 2002. Stop. Next para. Upon hearing the learned counsels for the parties and upon perusal of the provisions of Rule 15 of the rules of 2002, it only appears that the direction for payment to be made by the Deputy Commissioner and Block Development Officer, Charaideo District, will have to be recalled. Accordingly, the order dated 21/6/2019, insofar as a direction has been given for payment of the remuneration salaries of the writ petitioners by the Deputy Commissioner and Block Development Officer, Charaideo District concerned, Charaideo District is concerned, stands recalled. Stop. The state authorities shall, however, make necessary verification as was directed and forward the verification report to the Gaon Panchayat concerned in case there is an amount due for disbursement to the writ petitioners with the above observation.
And the concerned Gaon Panchayat shall pay, my lord, within a time bound, because this is.
No. We should not go to that extent also.
No, there was, the action for 3 months earlier, order, my lord. Now, Gaon Panchayat will, they will keep it pending for a long time, my lord. Because present members, they are getting their salary, current salary. But we are in the year 2019.
With the above observation and direction, the review petition stands disposed of. Before parting with the records, it is provided herein that in case any amount is found to be due to the writ petitioners to be paid by the Gaon Panchayat concerned, the same should be paid as expeditiously as possible and preferably within a period of 4 months
Review petition stands allowed, my lord.
from the date of receipt of the assessment / verification. Yes, review petitions are allowed.
Full prayer. Next item is contempt arising out of this order. Now the contempt has to be closed because they have obtained a certified copy and filed a representation to the present incumbents. In the meantime, the incumbents have changed. They will have to obtain a certified copy of this order and place it before the present incumbents.
Who has filed this contempt? You have filed.
Yes.
It has to be closed in view of the order passed today.
You'll have to close it then.
Yes, my lord. If it is a fresh order, so it can be closed.
Where's the order? Page. He's right. Heard Mr. H. Raman, learned counsel for the petitioners. Are you there in this case also? Who submits that this contempt petition has been filed for violation of the court's direction dated 21/6/2019, passed in WPC number 4243 of 2019. To stop, be it stated herein that this court, white order dated 27/5/2025, had recalled the order dated 21/5/2019.
In review petition.
No, had recalled the order dated 21/6/2019 in review petition number 18 of 2021. And therefore, in view of a fresh order having been passed, the instant contempt petition will have to be closed. Accordingly, the contempt petition stands closed.
My lord, my humble prayer, in the review petition order, Lordship will indicate that they will have to approach the present incumbent actress for verification. With this order, fresh order.
Present incumbent,
Yes, because earlier incumbents have gone now.
that's Charadio,
Yes.
DC and BDO.
They will have to obtain a certified copy of the order passed in review and along with a representation, they will have to. take
All right,
before-
I'll indicate that. All right.
Deeply. Okay.
May I please? My lord, in this case, my lord, by order dated 30/4/2025 in ISC, my lord, 1325/2025, the respondent number 9, 10, and 11 have been made party respondents, my lord. But notice was not served as reflected in the order dated 30/4/2025.
May it please your lordship. I appear for respondent number 4, my lord, and I have something to say today, my lord. So far as the respondent number 4, at that time, the respondent number 4 was district commissioner of the district. Now, my lord, I have been arrayed as a party by, it appears by mistake or mistake, so far as the order that has been alleged to be violated, in that the direction is, which is at page 15, my lord, if I may read it. Accordingly, the writ petition is disposed by directing the Director of Elementary Education Assam to place the recommendation made in favor of the writ petitioner before the next sitting of the state level scrutiny committee as required under the Act. Furthermore, we also provide that in the event the recommendation had not been made in favor of the petitioners, the chairman of the district scrutiny level committee, Kokrajhar, may inform the petitioners accordingly. Now, my lord, if I may just, if my lord may kindly take my affidavit that I have filed, my lord, at page 26. I've enclosed a copy of the notification of 2017,
Madam, just a minute, okay?
my lord.
Before you submit, continue to submit, let me just understand the order.
My lord.
Which is
At
the order?
Page 15
Page?
of the contempt petition, page 15. Paragraph 4.
It is start, my lord, page 13. Property part, my lord, page 15. Order dated 22/12/2020. There are 4 lots you will
Paragraph
find.
4, if I may just place it. We are in agreement with Mr. So-and-so learned counsel for the petitioners that there is a recommendation made by the district
SSC, DLSC.
yes, DLSC in favor of the petitioners. Accordingly, this writ petition is disposed of by directing the Director of Elementary Education Assam to place the recommendation made in favor of the writ petitioners before the next sitting of the state level scrutiny committee as required under the Act. Till here, it's okay. Further, we also provide that in the event the recommendation had not been made in favor of the petitioners, this is a direction cast, my lord, on the chairman of the DSLC, Kokrajhar, may inform the petitioners accordingly. Now, they have made me a party, giving my name and saying that I am chairman of DSLC, Kokrajhar. Now, what I am trying to point out that in my affidavit, I have enclosed a notification dated 29 August 2026, 2017, which is at page 26. I'm a wrong party, my lord. That is what I'm trying to point out, my lord. I am no way connected at all with the committee.
Mr. Mondal, what is this? Paragraph 4. First of all, it says that there is a recommendation made by the DLC.
Right.
If it's so, let it be placed before the SLC.
Yes.
Then again, it says that in the event the recommendation has not been made in favor of the petitioner, chairman of the DLC may inform the petitioners accordingly. What does it mean?
Now, my lord,
Does it not contradict a bit? It begins with that it is accepted that there's a recommendation. But it again ends at if there is no recommendation, then you may inform the petitioners.
Yes.
So, I mean, what is what?
My lord, perhaps, my lord, if I may say, my lord, perhaps the honorable court took the submission to be on the face of it as a correct submission, that there is a recommendation. So if there is a recommendation, the state level committee was directed to be, the director was placed to, directed to place the recommendation before the state level committee. And if there is no recommendation, then the only duty cast upon the chairman of DSLC was to inform the petitioners. Now, they have arrayed me as being the chairman of DSLC Kokrachhar, whereas I am not the chairman of DSLC Kokrachhar.
What are you?
I was just the DC of that district that time. And who is the chairman, I will place from page 26 of my affidavit, my lord. Because this is not a normal district, this is a BTC area, my lord. That is why a special provision is there. The district commissioner by default is not the chairman.
Then who's the chairman?
That I will pay from page 26 of my affidavit. I'll point
No, you
out the
just told
chairman
me.
is a principal secretary or his nominee. Sri Robinson Mushahari is a
Principal secretary of
BTC.
Okay. All right, that much I've understood your problem. What has happened to this case now?
Now, my lord, the last order, lordship kindly see the, my lord.
Are you
order dated-
recommended or not? Are you recommended by the DLC or not?
We are not informed, my lord.
You're
We
not
are-
you're not informed.
We are informed, my lord, we have been recommended by the DLC.
No,
That's fine.
you came to the court saying that you have been recommended.
Recommended, yes.
Then court said, okay, if you're recommended, let them place before the SLC.
Yes. Now, what is?
On what basis are you saying that you are recommended?
Yes, we have annexed the, my lord, document that we are recommended. Lordship kindly see in the contempt petition, we have also annexed, my lord, page 10, lordship is fine.
So if that is the case, then there is no question of you being informed that you are recommended. You yourself know that you are recommended.
Yes, we are recommended.
Now, what
Page
is to be
10,
done? Only thing which is to be done is that your case has to be placed before the state level committee.
Yes.
That's all.
Now,
Who will
whether it was
place-
placed before
Who
the
will place?
my lord, the director, elementary education Assam,
Who will place? Director.
director. It is
Where's the direction? Where's the direction?
There are 4, my lord.
Then who's the paying for director?
Yes.
For the present action, service is yet to be completed. Yet they have implemented a new incumbent notice. I think last.
We have also, my lord, made party, the present, my lord, incumbent.
Present incumbent.
Yes.
So notice is not complete.
Notice not complete, my lord. Notice to go, my lord. Lordship kindly see
Order
the
Huh?
order dated 34/2025 in IA number 1325/2025. Lordship will find,
Who's the new incumbent?
yes.
Narayan
Now-
Panwar.
Yes, Sri Narayan or,
He's the secretary,
yes, secretary, he is also made party. Then my lord Suranjana Senapati
director.
Director. and my lord.
So
Ashanti-
notice is not complete till now.
Yes. Notice should go to the respondent number 9, 10 and 11.
And the name of respondent number 4 may be struck off, my lord.
You're for number 4. Just a minute.
I'm grateful.
9, 10 and 11.
Notice should go, my lord. 9, 10 and 11.
Oh, notice has to go.
Yes, notice has to go. Just impleaded.
Now, sometimes this court used to pass
Yes, on the
Di-
same day, yes.
different type of orders.
Had it been passed, my lord.
Yeah,
you know,
this is stage by stage.
My lord,
It would have been easier if you have passed the order the same day,
my lord.
saying that you'll give the cost title within a number of days and notice should be issued within this time.
Now it is the
Anyway.
privilege of the court, my lord.
Hard, Mr.
MU.
MU Mandal Learned Counsel for the petitioner, who submits that notice upon the newly implemented respondent numbers 9, 10, and 11 has not been affected, since no order has been passed in that regard. Gustav, in view of above, issue notice to the respondent numbers 9, 10, and 11 by registered post with ADD. Petitioner to take steps within 3 days. Next para, at this stage, Miss
P. Sharma Goel.
B. Sharma Goel.
Goel.
B. Sharma Goel, Learned Counsel appearing for respondent number 4,
Yes.
submits that the respondent number 4 has been wrongly impleaded in the instant case, since he is not the chairman of the district level committee. He is or was not the chairman. He in this order. He never was the she never was the chairman oblique chairperson of the district level committee Kokrajhar. Stop. She submits that also, although the respondent number 4 was posted as the deputy commissioner of Kokrajhar, but it's a district council, isn't it?
Yes, autonomous council.
Since Kokrajhar, since BTC is an autonomous council, the district level committee is chaired by
Principal secretary, I think.
the additional secretary,
Principal secretary.
By the principal secretary.
by the principal secretary BTC. Stop. Therefore, the respondent number 4 has been wrongly impleaded and name should be struck off. We'll strike it off.
My lord.
Considering the submissions made, the respondent number 4 appears to be not a necessary party and accordingly is struck off from the arrayed respondents as paid for.
I'm so
All right.
grateful.
Now, when do we list the matter? List the matter again after 3 weeks?
Well,
Office to put up a note regarding service of notice upon the newly implemented respondent numbers 9, 10, and 11.
we have to take a step, my lord, within 3
3
days.
days. 3 days.
My lord.
Registered post, yes. One more item is. Today is a review court.
My lord,
So many review matters.
my lord, actually, what has happened, my lord, the honorable respected judge, my lord, has already superannuated, my lord. The order which we are seeking the review, that's why it has been, my lord, come up before my lord, my lord.
That is the procedure.
My lord,
If somebody superannuates, then somebody who's dealing with the
Take
same bench,
take up.
it comes up before that.
My lord,
So what is there
the-
to review?
The issue is very limited, my lord. We had been provincialized, my lord, both the review petition and under the 2011 Act. By FA, my lord, clear in a transparent process by the district scrutiny committee, by the state committee, and then by the director. And the ultimately provincialization order had been issued, my lord, provincializing our services as an assistant teacher in a school, my lord. Now subsequently, my lord, suddenly this provincialization order had been withdrawn, which they cannot, the director, my lord, because once, my lord, we had been provincialized under the statute, the law is very clear, my lord, under the definition of the section 2H, we become the employee of the government. Now, once we become the employee of the government, my lord, we are protected under Article 311 as well as the Services Discipline and Appeal Rules of 1964. My lord, those procedures they have violated, they have not complied with. Now, my lord, that cancellation of the provincialization, we came up before my lord, by challenging the said cancellation order. And accordingly, my lord, a order had been passed by the Honorable Learned Single Judge, my lord. That order which we are seeking review, my lord may be pleased to find is at, my lord, page 45, my lord.
This matter is listed for orders today. Why?
Orders for
Why
today.
orders?
It needs a hearing, my lord. Needs a hearing, my lord. Some time is required, my lord. Because, my lord, we are already protected by a review order, my lord, passed by the another division bench, my lord, wherein those persons whose services had been provincialized, there is a clear order that they should not be disturbed, my lord.
But the review petition will have to be listed for orders, isn't it?
Yes, because
It's
Lord,
normally not listed for admission and all that.
petition, no, my lord. It is generally come up as an order.
For
item.
orders only.
That's the reason.
Now, who's for the other side?
Lord, the elementary department.
Otherwise, we have filed our affidavit here.
Fine.
All right, when? Notice is complete in respect of the respondents, all of them.
My learned friend is appearing.
Okay. When do you want it? Then,
Lord, we have some urgency because we are jobless and we are also without any salary, my lord, because of the termination.
please write, parties are represented by the respective councils. And it is submitted, the pleadings are complete and the matter can be taken up for consideration on a fixed date. In view of above, list the matter again on so and so. When? 2 weeks.
Okay, for
On 26/6.
oblige, my lord.
So we'll resume at 2.
26/6.
Yes, what is that?
Madam, kindly have the second last order, Madam, 24th of March, I think. I was asked to produce the minutes of the meeting whereby the suspension of the petitioner has been extended. Madam. So what I pray, my lord, today, kindly give me 2 weeks time, my lord. In the meantime, I'll file the affidavit, my lord. Because one maintainability question is also there, my lord, which I have raised on the very first date.
What is there?
Maintainability of the petition, my lord.
Maintainability.
Yes, my lord. Because there is
The
already.
appeal lies. Appeal lies, you say.
Yes, my lord.
Appeal lies.
Appeal lies under the statute, my lord.
My lord.
Yes.
Yes, my lord. My lord, now, my lord, in this matter, my lord, there was 2 previous orders, my lord. On the first order, my lord, 24th of March, my lord, there was a direction that the meetings of the provisional periodical meetings for the suspension that should be produced and the stage of the departmental proceedings should be informed to the court, my lord. Now, my lord, what has happened in this case, my lord, I have handed over a list of dates, my lord. Successive departmental proceedings has been initiated against this petitioner, my lord. Now, initially, my lord, in 2023 October, the first disciplinary proceeding was initiated. Rashid, kindly have that list of dates, my lord.
Just a minute, Mr. Counsel.
Yes.
The sound is a bit less. I can't hear you properly. Just raise the volume. Can you increase the volume in your case?
Yes, my lord. I have also done it from my side.
Now it's better. Yes.
Is it better now? Yes, my lord. My lord, what I am saying, my lord, that successive departmental proceedings has been initiated against the petitioner, my lord. The first was done in October 2023. Lordship, may I kindly have my list of date which I have handed over, which is with the court master, my lord. Kindly have a look at the list of dates. It's a 2-page short list of date, my lord. Lordship has it.
See, one thing, why is it listed today? Why is it listed for?
My lord, it is listed because they were asked to file their reply. Twice time was given. What is happening here, my lord? Back to back, they are taking time. Then the suspension order, I have challenged the suspension order in this writ petition.
See, okay. Now today, see, I don't know whether you are aware or not.
Yes, my lord.
Counsel for the department has handed over me a meeting minutes.
Right.
By which this is dated 27th of January 2025.
Yes, my lord. Precisely, my lord. This
Signed
was
by the Secretary Higher Education.
right. This was
wherein the suspension period has been decided to be extended.
right, my lord. So this has expired, my lord. This suspension period is for 3 months because this was done before my filing of the writ petition. This has been annexed, impugned by me. This order has been impugned in the writ petition, my lord. Lordship will find this order in my writ petition at annexure 21.
Okay, the order you annexed, but this is the decision which they have produced.
Right, my lord. So therefore, my lord, as per the disciplinary proceeding rules and the guidelines of DOPT, my lord, every 3 months, if a person is suspended, my lord, every 3 months they have to take a decision whether to extend or not to extend. My challenge is on 2 grounds, my lord. First, my lord, that these are allegations against him in the second DP. The allegation against him is of 2017. So in 2025, there was no need for, after 6 years, my lord, there was no more than 6 years, my lord, there was no need for suspending him. He is not even in that office. These allegations pertain to Directorate of Higher Education, my lord. He is when he was suspended, my lord, he was the principal of the Assam Engineering College. After 7 years, my lord, this has taken place. Now, even they renew, my lord, because this order is of 27th of January. 3 months is expired. If there is no renewal, and the review committee has not applied its mind to extend the renewal, my lord, that suspension order is revoked, my lord, automatically revoked, revoked, my lord. So, my lord, this is one. Lordship, may kindly have my list of it. I'll quickly take your lordship. It will not even take 1
Hey,
minute.
what we'll do is, you see, I think you should come physically and argue the matter. Because
Sorry, my lord,
there's some technical glitches there. Number one. Number two, that counsel is praying for some time to file the affidavit. Probably, perhaps we'll give them some time and fix a date.
Very short date may be fixed, because he is not even getting his salary. That is even the compensatory salary, 50% of the salary. That is also not released for the last 7 months.
I'm saying here 2 weeks time, madam. Nothing.
Sorry?
2 weeks time, madam. Nothing.
2 weeks time.
Lord, let it manual, lordship may fix. I will come, Lord. I will come physically, my lord. It will be. He is not even receiving getting his salary, my lord. The 50% salary under suspension is entitled to get for the last 7 months.
Salary, what is that salary? Is it subsistence allowance?
Subsistence allowance, correct, my lord. Absolutely. Even that is not released, my lord.
What is your instruction on that?
Regarding subsistence allowance, my lord, I have to take instruction whether that has been paid or not, my lord. I will take.
You have not received. Since when, Mr. Counsel?
October, my lord. 30th October is the suspension order from November till date.
You have not received?
Not received.
November of last year?
November last year, yes. For last 7 months. So I'm only requesting, my lord, a short date and I will come physically, my lord. In the meantime, they can file within a week's time. Because they repeated, this is the second disciplinary proceedings, my lord. First disciplinary proceedings, my lord, he was asked to go on compulsory leave. That was set aside by the single judge. So once it was set aside, they again place him on suspension.
All right. Anyway, we'll consider that. Let him file the affidavit.
Right.
We'll give him 2 weeks' time. Your good name?
Rituraj Biswas, my lord.
Heard Mr. R. Biswas, learned counsel, who appears through VC. Also heard Mr. S. Das, learned counsel for the
Higher Education Department.
Higher Education Department, who submits that he may be given 2 weeks' time to file the affidavit in opposition. Stop. The learned counsel for the petitioner submits that the petitioner has not been given a subsistence allowance entitled to him since November 2024.
I'll take instruction.
Sub-learned standing counsel shall obtain instructions in this regard and make an endeavor to file the affidavit on or before the next court date.
Minutes of the meeting may be taken on record, my lord. There is.
Why don't you file this in the affidavit itself? Yes, because newspaper it goes here and there, we don't know where it'll go.
There is a specific direction that I'll annex, my lord.
The affidavit to be filed shall also. Now, the minutes of the meeting dated 27/1/2025, by which the suspension period of the petitioner was extended, was recommended for extension, shall also be annexed in the affidavit to be filed, along with all other relevant materials. List the matter again on so and so.
My lord, may I request one thing, my lord?
Yes.
Within the stage of the departmental proceedings, he
Hmm.
should mention in the affidavit because that was the direction.
All
First,
right, one more line. The affidavit to be filed shall also mention the stage of the departmental proceedings, the current status of the departmental proceedings said to have been drawn against the petition. List the matter again on
a short date may be, my lord.
19/6. 19/6.
Achalo.
All right.
Great.
Wait, please.
Yes.
First, as per last order, we have taken steps, your lordship. Service report is awaited, your lordship. First, we will take fresh steps, your lordship.
When did you take steps?
Lordship?
Respondent number 5, is it?
Yes, your lordship.
Which respondent? Okay, please write office note dated 23/5/2025 indicates that notice served by usual process has been effected upon the respondent number 5. Insofar as the AD card is concerned, the same is not received back till date. In view of above, office to track the postal consignment and put up a note by the next date. List the matter again after a week
What's the date may be fixed, your lordship.
on so and so.
Highly obliged.
11/6.
May I please, it's a contempt application, my lord. Respondent has today handed over a communication letter regarding the compliance of this order, my lord. My lord, at least 1 week time, my lord, to my lord, regarding the instruction from the client, regarding that my lord, order, my lord, communication letter, my lord.
You need 1 week time.
1 week time.
For
I'll
what?
take instruction from the petitioner, my lord.
Oh.
Regarding this, my lord, letter, my lord, who is handed over today only, my lord. As otherwise, we have already complied. We have given that benefit of the national benefit. This is already retired long.
Okay, as paid for petitioner, counsel for the petitioner is granted a week's time to obtain instructions as to whether the order of this court has been complied with or not. List again on so and so. 12/6.
Obliged, my lord.
It is complex, no? My lord,
On last occasion, our lordship directed me that he has stated that he was not called for the hearing. So lordship directed me to whether that his signature he was there in that hearing. No. He was present during the hearing.
Hearing for what?
As per the honorable compliance of this honorable.
No, hearing for what purpose?
To hear that for the purpose of provincialization, Lordship. Provincialization.
Provincialization
There is direction in the honorable.
of service.
Yes, Lord.
What is the name of the petitioner?
Pradip Kumar Roy, Lordship.
Kumar Roy.
Hmm. So what remains?
Maybe close.
This
If
was
they
the
comply,
this was the compliance order.
If they agree, my lord, he will
He
challenge.
will challenge this one if there is any grievance.
Because his name was initially not recommended by the district scrutiny committee.
Your good name heard, Mr.
M.R. Khandakar.
M.R.
Khandakar.
Khandakar, learned counsel for the petitioner, and Mr. S.M.G. Chisti, learned counsel for the respondent. This contempt petition has been filed alleging willful and deliberate violation of court's direction dated 27/2/2023, passed in WPC number 5721 of 2021. So Mr. S.M.T. Chisti on the last occasion had submitted that the order of this court has been complied with the passing of the order dated 19/11/2024 by the Director of Elementary Education, Assam. However, learned counsel for the petitioner had submitted that petitioner was not given an opportunity of hearing. Stop. In view of such submission, Mr. S.M.T. Chisti, learned counsel, was asked to obtain instructions in this regard. Stop. Today, he has produced the attendance of the hearing which was conducted on 15/9/2023 in connection with WPC number 5721 of 2021, wherein the petitioner has clearly appended his signature. Post of the learned counsel submits that the petitioner was not only present, he was heard. He was given an opportunity of hearing. Post of considering the submission made. And upon perusal of the attendance sheet produced by Mr. S.M.T. Chisti, it appears that the orders of this court has been complied with. Accordingly, the contempt petition stands closed. The attendance sheet dated 15/9/2023 is being retained in record and marked as X for identification.
Deeply obliged.
Item 50, we have complied with the direction. Direction was the petitioner will file an appeal and the respondent one commissioner secretary, he will dispose of that appeal, Lordship. Lordship, may kindly turn to page 12 of the contempt petition. Last paragraph. So that appeal was disposed of by the commissioner, Lordship, rejecting the case prayer of the petitioner. The appeal was disposed of.
What is the appeal about?
My lord. Lordship will find the order at page 9, my lord.
Can you tell me in one sentence, what is the appeal about?
For provincialization of his service.
Provincialization of service. So order is passed.
Yes. My lord.
Can be closed.
Can it be on next week, my lord? I think, my lord, the ground they have taken, my lord, what is the next?
You're not
course of
happy
action?
about it, you challenge it.
Yes, that
You
is
will close it.
in contempt, Lordship.
Then, my lord, my prayer, my lord, the liberty may be granted to challenge this, my lord.
Of course.
Yes.
Without liberty also you can challenge it.
Yes,
There's no bar.
Yes, lordship.
Heard
liberty.
Mr. P.K. Dekal, learned counsel for the petitioner, who submits that the contempt petition is filed for willful and deliberate violation of the court's direction dated 18/8/2022, passed in WPC number 4413 of 2021. Stop. Mr. S.M.T. Chisti, learned counsel, by producing order dated 11/3/2025, passed by the Secretary to the Government of Assam, Department of School Education, submits that the order of this court has been complied with by the respondent authority. Full stop. He submits that direction was to consider the appeal to be filed by the petitioner. And the same has already been done. In view of above, the instant contempt petition stands closed. Petitioner will be at liberty to file, to challenge the order so passed by the director,
By the secretary, my lord.
by the secretary, Department of School Education. If aggrieved. To stop the order dated 11/3/2025. 11/3/2025 is retained in record and marked as X for application.
Deep localized.
May I please, your lordship?
Yes.
My lord, this matter, in fact, my lord, relates to a inquiry report and arising out of a complaint made before the chief minister's special vigilance cells by an informant, my lord, and during the course, my lord, the informant died. My lord, now I have challenged the inquiry report.
And IA is for?
Lord, the IA is for, my lord, what is happening? My lord, the concerned investigating officer, my lord, frequently summoning me. And my lord, although I have cooperated with my lord with the investigation going and appearing, but they are frequently summoning me, my lord, without any valid reason. So, my lord, I am just praying that no coercive action may be taken against me by the investigating officer, my lord. That is my limited prayer in the IA. So now, what is the status, my lord, in the But on the last occasion, my lord, the government has on, my lord, may kindly peruse the order dated 14/9/23, my lord.
In the writ petition?
No, in the IA, no.
Or in the IA?
In the IA, my lord.
IA, there is no such order.
My lord, may kindly peruse the order dated 12/6/2024, my lord. In IA 3297 of 2023, my lord.
It says that some more time is prayed for to file affidavit.
My lord, but
That's all.
till date, my lord, we have not received any affidavit, my lord. My lord, can we pray, my lord, that let the investigation goes on and I will cooperate, my lord, but I should not be inflicted any coercive action, my lord.
What sort of investigation? What is the allegation against you?
Allegation is that, my lord, having some fake certificate of the PhD, by taking recourse of that certificate, I am trying to take advantage of my service benefits. In fact, my lord, that inquiry.
What are you? What are you?
I am, my lord, at present is the assistant professor in the Department of History in a degree college, my lord. It is a college named Borkhetri College in the district of Nolbari, my lord.
Assistant professor.
Assistant
Any inquiry done against you?
Inquiry is against me.
Any
my lord.
proceeding drawn?
Yes, my lord, the proceeding they are basing on a complaint, my lord, they have already proceeding with the investigation, my lord.
Investigation only. You're not suspended.
No, I have not been suspended. my lord.
Okay.
But I am, my lord, apprehending that I may be arrested or any kind of coercive action they may taken up, my lord.
Yes.
My lord, if he is apprehending arrest,
Then
I believe he should approach
for
for
bail.
bail, my lord.
My lord.
Anticipatory bail.
Anticipatory bail, my lord. That is my understanding.
No, my lord, what has
Okay.
happened?
What about any other apprehension apart from arrest?
My lord, that is, he can say his apprehension, my lord.
Then my lord can hear the main petition and can be disposed of, my lord. With the
Is it ready for hearing?
Yes,
Amended
yes,
petition.
service is completed, my lord.
Then we list it some day
Affidavit.
on a particular date.
Yes, my lord.
Not today. Today is listed for orders. I is listed for orders.
Reading is not consideration, my lord.
So you don't want to press the IA?
Lord,
Should we close it?
it can be remain, my lord, and at the one time, my lord can dispose of both the.
Okay.
If something happens, then there is a scope, my lord, that I can come and pray, my lord.
When do you want it?
Affidavit is not, we have not received affidavit.
Affidavit.
We haven't filed affidavit.
Oh, you have not filed affidavit?
No.
In the amended petition?
The writ petition, my lord.
But there are
This is a 2020 matter, my lord.
There are something else. What is this? This affidavit is by the petitioner or what?
Additional affidavit, my lord. we have
Oh,
filed.
additional by the petitioner,
Petitioner, my lord.
not by the respondents.
No, my lord.
When will you file then?
My lord, we will file affidavit in 2 weeks, my lord. We have received instructions.
My lord.
Mr. Dhar, you represent whom?
I'm appearing for my lord.
Magad University notice person.
Special vigilance or what? DGP.
My lord, 1, 2, 3, 4, 5 and 6
As government advocate.
as government.
No, no.
Then Magad University.
University, my lord, somebody has to hear, my lord. That is in Bihar, my lord, so I don't know whether
Another addition.
they have received, whether services complete upon them.
My lord, the office note dated 12/6/23, my lord. As per the track consignment report, it is found that the item is delivered upon the respondent number 7 and 8, my lord. Now 8 has already expired, my lord. 7 has, my lord, received the notice long back, my lord.
Long back means when?
My lord, office note date 12/6/2023, my lord, may kindly have a look, my lord. It says that however, as per the track consignment report, it is shown as item delivered addressee upon respondent number 7 and 8, right? Flag PC 8 at Panchayat.
Okay, the date of the office note is 12/6.
My lord, my lord,
Now, when the matter was listed again on 14/6,
14/6, my lord.
you were directed to take steps again.
We have again taken Dasti, my lord. And Dasti affidavit also we have, my lord, filed,
What,
my lord.
what is the status of Dasti?
No, we have filed an affidavit, my lord. My lord, may kindly peruse the office note dated 8/11/2023, my lord. And our affidavit date is, my lord, filed on 28/9/2023, my lord.
So what does the affidavit say?
No, my lord, it is our Dasti affidavit. Yes, my lord. we
What
take
does it say that you have served it?
Yes, my lord.
Or
So,
that,
my lord, may kindly.
or you could not serve it?
No, we have, my lord, may kindly peruse paragraph, my lord. Paragraph 3, my lord, page 130, running page, my lord. That the deponent begs to state that in compliance of the order dated passed by this honorable court, steps has also been taken for service notice upon the respondent number 7 and 8 for Dasti service by the deponent himself. The deponent has gone to Goa, Bihar himself on 4/9/2023 for service of notice upon the respondent number says that is Magad University. However, the university official refused to receive the copy of notice and petition and therefore notice returned answered. Therefore, the deponent returned on 5/9/2023. As regards the respondent number 8, so and so, although the deponent had himself gone to give him the copy of the notice, therefore, notice of respondent number 8 to return answered, my lord. Now, my lord, the refusal to accept, my lord, this amounts to acceptance, my lord. But registered post they have received, my lord.
Seven and 8, is it?
Yes, my lord, 7 and 8.
Are they necessary party?
Very much.
My lord,
The certificate came from their ballot. That is the whole crux of the case.
Seven has issued the, my lord, certificate to me of the PhD. And 8 is the, my lord, informant who lost the complaint. And, my lord, unfortunately, he died, my lord, recently.
Magad University.
Magad University, my lord. Lord, we have make our all effort to make them, compel them to come before my Lord, my
Is
Lord.
it in existence?
Yes, yes, still
It is in
exists.
existence.
My lord. They are functioning, my lord. They have an infrastructure there also.
Makadam question.
My lord.
So what is to be done then?
Lord, basing on our, my lord, affidavit, if my lord is pleased, my lord, then service can be treated to be complete, my lord.
What about the registered post?
Registered post office note is there, my lord. That is of 12/6/23, my lord. Nowadays, my lord, we can check the track consignment also, my lord, they through the official website of the postal department, which says, my lord, it has been delivered to address, my lord.
That is as per the office note dated
12/6/2023, my lord.
12/6, okay.
Lozima plus 409. The 12/6.
Okay, heard Mr. A.R. Bhuya, learned counsel for the petitioner, and Mr. Adhar, learned standing counsel. Learned government advocate
My lord,
for respondent numbers 1 to 6.
my lord.
No one appears for respondent numbers 7 to 8. Office note dated 12/6/2023 indicates that ID card has returned back from respondent number 7 and 8. No, submit indicates that neither ID card nor unserved notice has returned back from respondent number 7 and 8. Stop. However, upon checking the postal consignment, comma, the notice has been shown to be delivered to the addressee. Stop. Mr. A.R. Bhuya, learned counsel, submits that as permitted by this court, the petitioner tried to serve notice to respondent number 7 and 8 by way of Dasti. But the said respondents refused to accept the same. On being approached by the petitioner on 4/9/2023. Stop. Considering the above, the notices accepted to be complete on respondent number 7 and 8. On the prayer of Mr. Adhar, learned counsel, for respondent numbers 1 to 6, 2 weeks time is granted.
My lord. I will take some updated instructions. It's little old, my lord.
What happened to the inquiry, my lord?
To obtain instructions and to file counter affidavit. Yes.
Oblige, my lord. Lordship, in this matter, I'm appearing on behalf of Mr. R. Majumdar. He has some difficulty today, my lord. Can this matter be taken up on some other date, my lord?
Review matter.
It's a review matter, my lord. Mr. R. Majumdar is appearing. His name is there in the list. Appearing in
When?
this- Any day, my lord, the next week, maybe.
Mr. R. Majumdar, learned counsel for the petitioner, he said there are some personal difficulty to appear before the court today. Stop on a prayer made on his behalf and not objected to by the other side. Matter stands adjourned. You want a date?
Lordship, next week, any date.
To be listed again on 6/6.
Fifty-three lawsuits, we have issued the compliance order. I have already served a copy to my friend.
I'd like to take my lord to page 22. There is a specific direction, my lord. The respondent number 2, page 22, my lord. The Director of Elementary Education, Assam, is directed to give a fresh consideration to the claim of the petitioner in the light of directions passed by this court by so and so, in so and so, by taking into account the revised recommendation made by the District Scrutiny Committee on 16/11/2021. Now, my lord, there is a specific direction whether to give consideration to the recommendation made by District Scrutiny Committee on 16/11/21. Now here I have gone through, my lord. Now in this order, they are saying that the recommendation itself is invalid.
Yes.
Whether in contempt proceeding they can say so, my lord.
This is not a.
When there is a specific direction to consider in terms of recommendation. Now they in writ petition they have not said the recommendation is invalid. Now they are saying it is invalid. Further, one more ground, my lord. Earlier they have rejected my case on the ground that my name was not recommended by the District Scrutiny Committee. That has been interfered, my lord. By order, first para, my lord. Again, there is something here and there. They are saying again same order, my lord. My name was not recommended by the District Scrutiny Committee. This is the order, my lord. In view of the order of my friend produced the compliance, that is page 2 order. In view of the above circumstances, as the petitioner name was not recommended by the District Scrutiny Committee, Dhubri as per provision of Act and something at more or less ground is same, my lord. Earlier, same ground was interfered.
Well, the direction was to the director to give a fresh consideration upon the recommendation of the 16/11/2021. Lordship, kindly peruse the order in the last para, lordship, in the compliance order. Accordingly, the matter was placed before the SLSC, and SLSC decided that proposal for the provincialization of service of the submitted by the DO Dhubri by letter number so and so dated 1/1/2018, and the entire process for submission of proposal by the DE as per the recommendation of the SLSC after verification of joint committee was done based on the proposal dated 31/12/2020. In the said proposal, the name of the petitioner was not recommended by the District Scrutiny Committee. Hence, the SLSC could not recommend his name for provincialization of service, and the name of Shantiram Burman was included as per proposal dated 11/1/2018. Accordingly, his post was provincialized. It is pertinent to mention that the post of tutor was created as personal post, which is abolished on the retirement or death of incumbent, and it is very clearly mentioned in the provincialization order that as per Rule 21(1) of the Act 2017, the post shall be personal to the incumbent, and the post shall stand abolished on occasion of the service of the incumbent for any reason whatsoever, including retirement, resignation, death, etc. Moreover, District Scrutiny Committee Dhubri had never recommended the name of the petitioner for provincialization after the death of Shantiram Burman. That person who was provincialized in that post, he has died, and the post has gone, lordship, abolished. and who died on 6/1/2020 till the completion of the entire process of provincialization on 4/2/2021. The entire process of provincialization was completed on 4/2/2021. Next para is important losses. That is a fresh consideration. On the other hand, the name of petitioner Abdul Majid Pradhani was sent by District Scrutiny Committee Dhubri by minus dated 16/11/21. This is the revised recommendation that was Honorable Court directed the director to look into lawsuit, for which no instruction was given to the DO Dhubri. As such, the minus of the District Scrutiny Committee cannot be considered as valid. So the District Scrutiny Committee on its own has lawsuit. There is no instruction. And the process, then the post where that the other person was provincialized, and after his death, the post got abolished automatically, lordship.
In this case, what happened, my lord?
If he has any grievance, he will challenge this again, lordship.
No, my lord, my submission before my lord is that when that they can now say the proposal is not valid, when order is passed, specifically to consider, give a fresh consideration by taking into account the 16/11/21 proposal, my lord. But they have considered the proposal of 2020, earlier proposal. In this case, what happened, my lord? The one Shantiram Burman, his post was provincialized after his death. Before provincialization, he died. His name was recommended India 2018. He died in 2020, and provincialization was made in 2021. So post is not abolished. He has not joined. Before provincialization, 1 year provincialization, he died. So post is there. So honorable, in this case, the District Scrutiny Committee, it is under the Act. Director cannot say it is invalid. Under the Act, there is a District Scrutiny Committee. The committee has recommended a fresh, since post is there, because person died before provincialization. But my submission
So
before
lot of
my lord,
tax things are there, lordship. So
what factual, my lord?
he has to challenge
My
this.
clear submission before my lord is whether they can now say the recommendation made by District Scrutiny with 16/11/21 is not valid.
So where do they say in the order that it is not genuine?
My lord,
16/11/21 has been mentioned
yes, my lord, mentioned that is
anywhere.
this is
Second page, lordship.
second page.
Highlighted para, lordship. The second para. On the other hand, on the other name of the petitioner Abdul Majid Pradhani was sent by the District Scrutiny Committee Dhubri by minus dated 16/11/2021, for which no instruction was given to the DO Dhubri. As such, the minus of District Scrutiny Committee cannot be considered as valid.
My lord, whether the District Scrutiny Committee can he abolished by the director? It is under the Act, my lord. There is a section under section 13. There is a District Scrutiny Committee. The District Scrutiny Committee has to recommend the name of a person for provincialization. Now they have added that line. My submission before my lord, whether they can raise this now in contempt proceeding. Even they have admitted it is recommended by the District Scrutiny Committee. Further said, for which no instruction was given to DO. DO is not the chairman of District Scrutiny Committee, he is the member secretary. Deputy Commissioner is the chairman, my lord. There is a committee. So now in the contempt, can they say, when there was a specific order to give fresh consideration?
And that consideration was given, lordship.
It is nothing, my lord, only to reject my case. Earlier, they have also rejected, saying that my name was not recommended. Now something had been added. But that order was interfered. Saying that to give a fresh consideration.
And the post is no longer valid. That it has already got abolished, lordship. As per section 21, as per rule 21(1) of the 2017 Act, lordship.
My lord, the person who has been provincialized died in 2001, 6/1/2020. Provincialized was done on 4/2/2021. After more than 1 year, before provincialization, he died. Before 1 year, more than 1 year, he died. So post was there, he has not joined post. It is very clear in the my lord, order of this honorable court, that is my lord, from page 21. From page 21, my lord. It has been discussed. My lord.
Yes.
My lord, my specific submission, my lord, limited, whether since there was a direction to reconsider, to consider afresh my case on the basis of revised recommendation made by District Scrutiny Committee on 16/11/21. Now, by this order, my friend produced by my friend, the contemptor is saying that the proposal is not valid. Whether they can say in contempt proceeding. Why they have not said in writ petition that it is not valid?
Mr. Chisti,
Yes, sir.
there's a point. 16/11.
Yes.
2021.
Yes.
Court had made a particular observation. By taking into account the revised recommendation made by the scrutiny committee on so and so. But this apparently has been omitted. You take instructions,
Yes, Lord.
please write, although Mr. SMT Chisti learned counsel for the respondent as by producing order dated 23/5/2025 submits that the order of this court dated 15/12/2023 passed in WPC number 6127/2023 has been complied with. The learned counsel for the petitioner, Mr.
M.R. Khandakar.
M.R.
Khandakar.
Khandakar, submits that a specific direction was given by this court to the respondents to also consider the revised recommendation made by the District Scrutiny Committee dated 16/11/2021, but the same has been not taken into account as directed. Mr. SMT Chisti, learned counsel, prays for some time to obtain instruction in this regard, and accordingly, 2 weeks' time is granted.
May I pay date, my lord, as a tool?
List again on so and so.
I am deeply aware.
Fifty-four, I need some accommodation on behalf of Mr. B. Kaushik Losif. Losif, kindly, huh?
On behalf of,
Mr. Khatania, NJ Khatania Losif. 2 weeks time may kindly be given. I have already informed you.
So last occasion, they have taken 3 weeks time, Lordship, because they are.
now it's come down to 2 weeks.
Yes, yes.
Next time they'll take 1 week.
Yes.
They are- they
Yeah,
file-
24 metal Losif.
After 1 year of passing this order, they have preferred an appeal before the division bench. The division bench dismissed their appeal. Thereafter, they pass an order that we will comply this within a period of 2 weeks. The last order kindly see.
All right,
One week after 1 week.
we'll give them a chance.
Yes.
We take a week's time.
Yes.
As paid for on behalf of Mr. NJ Khatania, learned counsel, paying for the respondent. A week's time is granted to come up with instructions regarding the compliance of the court's direction.
Oh, he put to the whatever. Yes, yes. No point.
Maybe. As per office note dated 22/5, madam. Service upon all the respondents are completed. Maybe come up for admission.
All right. Office note dated. No, this is, please rewrite. Lavazima Court's order dated 22/5/2025 indicates that service of notice upon respondent number 8 and 9 is completed, has been completed. Stop in view of above. Notice is accepted to be complete on respondent numbers 8 and 9. Registry release the case for admission after 2 weeks.
May I pay for date? After any date? 19. How late?
When you give the dates, now.
A small issue is involved here in this petition, my lord. So far, my lord,
Or you'll take whole day.
no, my lord.
Huh?
Only 5 minutes is service.
It's like that. You see, when you start saying that it's a very small issue, then council starts arguing whole day.
Here, my lord,
Yes, what is the case?
The first wife of the deceased, my lord. The private respondent, my lord, number, my lord.
Pension. Pension matter
Pension,
between first wife and second wife.
my lord. The second wife has filed the affidavit, my lord.
Hmm.
Admitted my status, my lord, that I am the first wife. My lord.
You're the first wife.
Yes.
And you're the
That-
petitioner.
That is admission by the respondent number 6, my lord.
Okay. First wife and you're the petitioner.
I am the petitioner.
So what does the second wife say?
Second wife says, affidavit has been filed.
Here today they have filed.
No, on 2025.
I'm the appearing respondent number 678. So my senior is a engaged counsel. She's instruct me to give some time. Some emergency is coming, so she is unable to appear today before this honorable court. So
Have you filed affidavit?
yes, honor.
Already, my lord, affidavit is on record.
Well, we have not received a copy of the affidavit, my lord. What
Okay, you serve copy to the
My lord.
other parties.
My lord.
You give the offer. We'll have it on some day. We'll have a fixed date.
My lord, date maybe.
When is it convenient for the parties?
My lord, 8, 9, 10, I will not be available, my lord. Except 8, 9, and 10, my lord.
No, you just. Okay, I see like that. You keep this with you and I'll give the dates. A prayer for adjournment is being made on behalf of the council for respondent number 6, 7, and 8. Stop. The prayer is not objected to by the other side, but however, it is stated that affidavit filed by the respondent number 6, 7, 8 has not been furnished to the learned counsels appearing
I'm appearing for respondent 1 and 4, my lord.
to the
2, 3, and 5.
to the learned counsels appearing for the other respondents. So stop. As such, counsel for respondent number 6, 7, 8 to furnish the affidavit of opposition within 3 days. Release the matter on so and so.
Fine.
Give a date. Yes.
Since matter is related to family pension matter, we are also, my lord, standing for.
It'll come up after 2 weeks because, yeah, on 17.
7 minutes, my lord. Highly obliged.
Yes, honor.
Copy your phone number to me, oh, black. It's a mobile to.
Anyone there in this case? None appears for the petitioner when the matter is called. No one had appeared when the matter was listed on 29/2022 as well. This, for ends of justice, list the matter again after 3 weeks. It is also observed hearing that if no one appears on the next court date, court may consider dismissing the same for default. Yes, you're there.
Yes, Your Lordship. Item number 6 for the respondent.
Your good name?
H. Terampi, Your Lordship.
Miss H.
Terampi. Terampi.
Terangpi. You got it. Appears for the respondent. Which respondent? Which respondent number?
One entry, Your Lordship.
Okay, one entry. Yes. Hmm.
My lord, here, my lord, the petitioner is not getting the, my lord, it's an allowance in terms of the, my lord, notification of the 4/8/2018, my lord.
Special allowance.
My lord, special allowance.
For what?
Page 21 is the, my lord,
No. What is the special allowance?
special allowance as per notification dated 2/7/2018. It has been given to the graduate teachers of a high school, my lord.
For what?
That is the decision of the, my lord, government.
There must be something, there must be some reason for getting special allowance.
My lord.
What is the reason?
So for minorities, so for that part is concerned, the page 23 is silent. It was the recommendation of the, my lord, committee to the government. for
Okay,
providing
have
some
they
special
filed the affidavit?
Has filed affidavit, my lord. Our status has been, my lord, admitted that we are the graduate teachers, my lord. Now, my lord, lordship may take note of the.
Special allowance, is it because you have done your B.Ed or something like that?
Perhaps, my lord, not for B.Ed, my lord.
What is it for then?
It is, my lord, so for the notification concern, allow special allowance of this.
There's no explanation about that.
High school.
So
Against grade
everybody will get special allowance then?
Who is, my lord, during the grade pay of rupees 8,700. To him, the special allowance has been given by the authority, my lord. So for the notification that is 4/8/18 is concerned, my lord. Page, my lord, 25. my lord.
That I've seen. Now, why they're not giving you?
Because the basic ground is such that initially my appointment was in the ME school, my lord.
Okay,
That ME school has been amalgamated with the high school, my lord.
okay.
Now, I have been drawing the grade pay of rupees 8.
So this special allowance is only for high school?
As per, so notification says the graduate teacher who are drawing the grade pay of rupees 8,700. The basic condition is such, must be a graduate teacher.
Graduate teacher of which school? High school?
High school.
You are a graduate teacher of
High school.
high school, but
Yeah.
you were initially working in a
As graduate teacher in ME school, my lord.
graduate teacher in ME school,
My lord.
which was ultimately amalgamated with a high school.
High school, prior to, my lord, issuance of this notification. That too, my lord, prior to issuance of this notification. My school was amalgamated with the high school.
Okay,
Now I am a graduate teacher, my lord. I am serving in a high school, my lord. I am drawing the grade pay as prescribed in this notification, Annex B, page 25.
can you just tell me the history? Which is the school which you are working
My lord.
earlier? Where is the amalgamation order?
Lordship may take note of my additional affidavit, my lord.
Page?
Page, my lord. Specifically mentioned, page 42, my lord.
42.
Planning page.
Hmm.
Internal page 4.
Yes, what is that school?
So for petition number 1 and 2 is concerned.
Oh, how many petitioners are there? How many?
7 petitioners.
7. So all of your background is similar?
Schools are different, but
Schools are different.
But
So then
background
it becomes difficult because it'll be here and there. You should have prepared a chart or something.
Page 42, I have mentioned detail, man. Page
This-
42.
Oh, these are in paragraphs. I am talking about the
Yes.
chart.
So for the
So is that the only reason that
Or
before
failure.
amalgamation, you were working as a graduate teacher in a middle school?
I was a teacher in a MA school. I am working in the high school, but since I was working initially in ME school, that is why I have been not given the special allowance. This is the basic reason why I have not been given this amount.
Special allowance is what? It's added every month in your salary, rupees 300.
Similarly situated person are getting my.
What do you say?
Although they have been working in a high school or high secondary school, but their post is sanctioned for ME school only, not for high school or high secondary school.
But after
here-
amalgamation, they're working.
In the high school, but in the ME category.
I see.
Here,
I see.
we have filed our affidavit
So
to-
see,
in clause
he is also ready.
5.5.
You are amalgamated to the high school, no doubt, but you still work as in
ME.
the high school, but in the ME standard.
I am still drawing the graduate scale. Graduate teacher means that it has no differentiation in the high school that I am working in the ME post.
But this notification speaks like that.
But yes, sir. But
Allowance of so much amount per month
yes,
to graduate teachers
yes, ma'am.
of higher schools, higher secondary schools
Yes, ma'am.
against the grade pay of 8700. What is your grade pay?
870.
See, again, this also does not very clear. It does not say that
So once
the teacher has to be teaching in the high school.
Yes.
It says in the high school. So he's a graduate teacher in the high school.
But their post is sanctioned for ME school only, not
maybe-
for high school. Here, my lord, in our affidavit, paragraph 5, page 36.
Their post is sanctioned for
Sanction for ME school.
ME school.
Yes, not for high school.
But that clarification is not there in your notification. How do you debar them?
But here in the notification, my lord, after careful consideration of the report of the anomaly committee, the government is pleased to allow the special allowance of rupees 300 per month to the graduate teacher of high schools, higher secondary schools against the grade pay of rupees 8,700 with immediate effect.
Okay, one thing. Have you filed any representation?
I have a representation.
When?
Long back, man. That was not considered because of the fact that only
You file
one-
now?
only
Why
one-
don't you file now?
madam, yes.
So
And-
that will build up your case because right now we cannot decide that way or that. Because you say, I am a graduate teacher, initially working in that, now in the high school. He says, okay, you're in high school, but your post is not sanctioned. You're sanctioned against the middle school.
Yes, I mean,
So this will go on and on. So let them clearly take a call. And if you still agree, you may come back.
in last occasion, madam, in that regard, madam, clarification has been sought from the government, madam. I have to put on the record, madam.
What has been sought? Instruction.
Clarification as regards to
Clarification, how?
last order, madam.
Last order is adjournment.
About order.
Before that also adjournment. Before that also adjournment. Where clarification?
That is
Depends upon finance. Let's put down finance. No.
I think 21-6.
madam.
Respondent shall let affidavit be filed incorporating the stand. So it was affidavit only.
Madam, can it be, madam, done that the government shall clarify as regards to my position in relation to that notification to that affidavit, madam.
No, they have
So for-
already said now
Yes, madam. So
that
for
you are not in
inter-
a sanction post.
Yes, if
You are sanctioned only for ME school.
get clarification through affidavit, maybe filed there.
Is that in your affidavit?
But yes,
That
my
is
lord.
not affidavit.
In our affidavit, it is stated that in point number 5.
Affidavit,
Yes,
point number 5,
yes,
paragraph number 5.
yes.
The opponent, while categorically denying the claim of the petitioner for receiving the special allowance of rupees 300, it is stated that petitioners were working initially in ME school and later on they are now working at high school by virtue of amalgamation. As per Government Finance Department order so and so dated 4/8/2018, the special allowance of rupees 300 per month is allowed to the graduate teachers of high school and higher secondary schools against the grade pay of rupees 8,700 only. The said special allowance of rupees 300 is not extended to the teachers who were initially working in ME schools and later on are working in high schools by virtue of amalgamation. In other words, there is no provision of special allowance of rupees 300 to any teacher appointed against the sanctioned post of ME school. The said special allowance is given only to the graduate teachers appointed against the sanctioned post of high school or high secondary schools. As such, the petitioners are not entitled to special allowance of rupees 300 as paid for being initially appointed against sanctioned post of ME school.
Is there any notification in that regard? Otherwise, it becomes a matter of interpretation only.
Only
Sir,
this
so far
notification
interpretation
is there.
is concerned, may I submit? When the authority has interpreted, that is the true affidavit, that since I was appointed in a ME school, so such benefit has not been given to the person whose initial appointment was in ME school. But so far the intent and the contents of the notification is concerned, a particular nowhere it is stated that any person who was initially appointed in a ME school are not entitled. The graduate teacher of any high school or higher secondary school, two conditions are there. One is whether he must be a graduate teacher, and second condition is he must have withdrawn the grade pay of rupees 8,000.
When did the amalgamation happen?
My lord, in the year 2018, that is the
Amalgamation.
yes, my lord. All are, my lord, amalgamated prior to issuance of that notification.
When? Notification is 2018.
Uh,
Your amalgamation is when?
2018 and 17, my lord.
Your amalgamation, when?
Yes, yes.
17, 18?
First one is, my lord, 2016. Second one is, my lord, 2017.
No, what do you mean?
My lord, 7 petitioners are there.
How many amalgamations required?
My lord,
One is not enough.
no. All the petitioners are not from one school.
Oh, there are a lot of petitioners. Okay. 17, 18.
16?
But this notification is also 18.
No. No, yes, sir.
Page 25. You only
Page-
showed me annexure B, page 25.
2018.
4/8/2018.
Yes. My petition so far amalgamation of petition number 1 and 2 is concerned, amalgamated with effect from 1/1/2018. 1/1/2018. And so far is the petition number 3, 5, 6, and 7 is concerned, 16/6/2017. Almost 1 year,
Anyway, I think Mr. Counsel
my lord,
will have it some other day.
my lord,
The reason being,
my lord.
I want you to prepare a chart.
Okay.
Chart.
My lord.
When amalgamated,
Yes,
who were the teachers?
Yes,
And you also will come with some authority.
my lord.
If this amount is given to somebody who is working in the school as such, I cannot be deprived of. I should be given at parity. Some authority should be there.
I am
Because the affidavit which they have given here at page 36,
my lord,
which Mr. Sharma has read,
I have gone through, my lord.
they have explained why they are not
On the
giving you.
ground that-
So this interpretation will have to be done.
Right.
And for that, I think I need some authority. Otherwise, tomorrow they will go and to a larger bench and they'll come back again.
My lord, a date may be
All right.
fixed, my lord.
As paid for as paid for by the parties, let the matter be listed again after 2 weeks. 19/6. Learned counsel for the petitioner shall prepare a chart
Right.
for the convenience of all the parties concerned. In respect of the date of amalgamation for in respect of the date of amalgamation of the schools concerned and other details. Yes.
All right.
R Boro appears for respondent number 7.
Four.
Okay, number 4, fine, yes.
Next, please, Your Lordship.
Hmm.
My lord, in this matter, my lord, the petitioners are teachers, my lord. They were appointed in between 90 and 2003. There are 8 petitioners, my lord. At the time of appointment, my lord, the appointment was made by the managing committee, my lord. Because that at that
What
time,
is your grievance in one sentence?
in one sentence, my lord, the petitioner praying for pensionary benefit under the pension rules, my lord.
69
Yes,
Whether
Your
they'll be covered by the old pension scheme or new.
or new pension scheme.
Yes.
But where is your affidavit, Mr. Chaliha?
Lordship, we have received the instruction, Lordship, here. If there is a judgment which my learned friend has put over here, Lordship, if they are similarly situated, if they are drop teachers, Lordship.
No, why is there a dispute? Is there not a cutoff date for old pension and new pension?
Cutoff date is, Lordship, 1st of every 2005. 1st of every 2005.
Okay.
Now here, all these appointments which my learned friend is relying upon, Lordship, the issues are these appointment letters have been issued by the school managing committees or inspector of schools who do not have the authority. Officially, Lordship, they have been appointed. Lordship, if
What do you mean they don't have the authority?
these
See, it may so happen that they were appointed initially by the managing committee or whatever.
yes.
Later on regularized.
That is what, Lordship. Regularized, they were regularized and they officially came under the government domain, Lordship.
No, if it is regularized, then what?
They were
That means from day
regularized
one.
in 2014, Lordship. They
So regularized from day one then.
not from
If it was unauthorized appointment,
yes, Lordship.
then you could have said that we cannot regularize you.
Yes, Lordship. So
But you have regularized it.
no, we have not regularized them, Lordship. We have regularized them in the year 2014, Lordship. Page 37 of the writ petition.
Anyway,
With effect from 1/1.
you have your own affidavit in opposition. You're relying upon the writ petition to argue the.
No, affidavit, Lordship, I'll file. But
When
Lordship,
will you file?
in their own writ petition, Lordship, I can point it out, Lordship. The order in which the name is reflected, Lordship.
Anyway, we want you to file affidavit.
Yes, Lordship.
That's all.
Lordship, education will also be required because they come under the category of drop teachers. As in now, there is an.
It's a Karbi along matter, so we have already written a letter to the inspector of the school.
We'll file our affidavit, Lordship.
So,
Details, my lord, come to from the Karbi along.
all right, don't give me that letter. Why don't pass on letter like that? Don't give me that letter. You write to your Karbi Anglong
Yes.
thing. What can we do?
They have been not made a party, Lordship, I think.
Who's not a party?
They have not been made a party, Lordship, because since they have.
Who is not a party? Karbi along.
Why they required to be a party?
Lordship, because the appointments were done.
No,
by
it is there. It is there. Respondent number 3 is inspector of
yes.
schools.
Then maybe. Maybe in the names have not been reflected, Lordship. Otherwise, Lordship, here.
Don't bother about that thing.
Yes.
We'll take care of that.
Otherwise, it has.
Please file your affidavit.
Yes,
Whatever you have to
yes,
say,
yes.
please say it in affidavit.
That is 22 meters, so kindly direct the
I will-
file their affidavit within a certain period.
Yes, Lordship may fix it immediately at reopening, Lordship. We'll file our affidavit, Lordship. Finance will file their affidavit. Reopening of July.
Why? My lord,
Oh,
in the
Lordship.
corporation, my lord, Karbi along standing council has not shown here, my lord.
Okay, don't worry about that. We'll take care of that.
Lordship, because they are not entitled, because they have admitted that they are drop teachers. Drop teachers, there is an appeal pending right now, Lordship, where it has been categorically stated only stipendary teachers will be getting the old pension scheme, nobody else. The judgment which my learned friend has annexed here, Lordship, here it's categorically stated
Please
that
write down.
drop teachers.
Please write down. Claim made by the petitioners. Is for pension under the Assam Service Pension Rules. Which year? 1953?
1969.
1969. The respondents have not filed their affidavit. To stop having regard to the projection and claim made by the petitioners, a response will be required from the respondents. Stop accordingly. How much time? 3 weeks?
3 weeks.
3 weeks time is granted
The others will also be required, Lordship, we'll file it.
to all the respondents for filing their counter affidavit. This the matter again on so and so. 24/6.
Standing Council Karbi Alang name.
Standing Council, Karbi Anglong.
And-
KAAC, is it?
Yes.
KAAC.
Yes.
SCKAAC may be reflecting the cost list hereafter.
Please, Your Lordship. Lordship, in this matter, I have filed an IA for impleadment of party, Lordship, which is yet to be listed. Therefore, Lordship, 1 week's time may be given, Lordship. In the meantime, we will file also reply, Lordship.
What do you want to file?
We have already filed IA for impleadment of
Ah.
party. Now,
You file impleadment for IA for impleadment, and you also want to file reply also
yes, Lordship.
to your own IA.
Not, Lordship, in
Lordship,
this
we have
main
filed our affidavit in opposition, respondent number
two,
2.
Lordship. Regarding
Okay.
this.
No, for impleadment, impleadment is allowed.
No, Lordship.
Not
we have
yet,
filed, but yet
File
to
and-
be listed, Lordship.
Oh, I see. Okay. As paid for by the Royal Council for the petitioner. How much time?
1 week's.
A week's time is granted for filing rejoinder affidavit.
Obliged.
Obliged.
May I please, Lordship? This matter, Lordship, relates to the payment of the compensation family pension, Lordship.
Family
The
pension.
government of Assam, my lord, introduced, my lord, a scheme, Lordship. In lieu of, my lord, the compensation and appointment, Lordship. The government has decided to, my lord, pay full salary to the, my lord, kin of, my lord, the deceased employee, Lordship. Now that notification is at page 21, can you see? Page 21, office memorandum, Lordship. Now page 22, my lord.
Just a minute, just a minute. Yes, what is your claim, by the way?
The claim is, my lord, for my lord, compensation family pension, Lordship.
Compassionate
Family pension.
on what ground?
My lord, yeah, the two petitioners are there, Lordship. Two is, my lord, the mother of the deceased, Lordship. She is nominee, Lordship. My lord, on that, my lord, the strength, Lordship, the petition number 2, mother claims.
No, what I meant to say was that who is entitled for a compassionate
As per,
family
as
pension?
per nominee, Lordship, as per, my lord, rule 137 of the, my lord, pension rules, Lordship. Nominee is entitled, Lordship. Otherwise, my lord, it is entitled.
You
to
said
my lord,
compassionate
pension.
family pension.
Family pension, Lordship.
Compassionate family pension.
Compassionate family pension, Lord. Now, kindly see page 22, Lordship, the guidelines, my lord.
No, what is this concept of compassionate family pension,
Lord,
Mr. Pegu?
those employee who died after 1/4/2017, they are entitled for family
Instead
pension.
of compassionate appointment.
Yes, ma'am.
Yes, Lordship.
Okay, say that.
But
I
here,
was wondering what.
Now, page 22, kindly see, Lordship.
And here,
Yes.
on last occasion, some directed to receive instruction, my lord. I am praying for 1 week time to receive instruction.
What kind of instructions?
That
What?
whether that application has been submitted before the DE or not. Kindly go to the, my lord, last order.
Well, as well as the, my lord, status of nomination, Lordship.
Okay, Mr. G. Pegu is granted. a week's time to obtain instructions in terms of the court's order dated 17/2/2025. List again on so and so.
Obliged.
Hmm.
Obliged.
If none appears for the petitioner when the matter is called, list for ends of justice. List again after 3 weeks.
May I please also? My lord, in this case, SSC is necessary party. I have already filed the. Kindly see the office note dated 3/10/2025, madam. Sir, pertains to position from the phone.
Yes, you were saying?
Pertaining to this matter related to my lord, non-provincialization LP school, my lord. In this case, Sarva Shikha was not a party. I have filed IA and already IA is disposed of and I have filed the impleaded cost title, my lord. But
Which respondent number?
respondent number 6, my lord.
6. Anyone appearing? Mission Director.
Mission director.
Mission Director SSA.
Yes.
Is there any standing counsel SSA? Okay, then we'll list it some other day.
Yes.
My lord, similar matters fixed on 2nd of June, my lord. Same matter.
Okay, list this matter. You have the case number?
6.
Anyway, we'll list it on that date, 2nd of June.
2nd of June.
As paid for by the learned counsel for the petitioner, list the matter on 2nd of June 2025. The name of SC, SSA be reflected in the cost list hereafter.
May I plead your lordship?
Yes.
Your lordship, I request for 4 weeks' time to file affidavit, your lordship.
Okay. This is a 2022 matter.
Yes.
You are appearing for which respondent?
Your lordship, Standing Counsel, Assam University. I'm appearing on behalf of SCKLC.
SCKL.
Yes, your lordship.
Yes, we'll give this some more time.
Yes.
How much time should you require?
Your lordship, 4 weeks.
4 weeks time.
Yes, sir.
Date may.
That's paid for by the Learned Standing Council, Assam University. 4 weeks times, further 4 weeks time is granted for filing counter affidavit. List the matter again on so and so.
Obliged.
17.
My lord, the matter will be taken up for any other day, my lord.
Why?
I could not gone through the brief, my lord.
Sorry?
Could not gone through the brief, my lord.
Okay, your good name?
B. Chanda, my lord.
Mr. B. Chanda, Learned Counsel for the petitioner submits that he may be given some more time to prepare the matter. Mr. P.J. Pugan, Learned Counsel appears for the Guwahati University. As paid for, list the matter again. When?
After 3 weeks, my lord.
Your good name?
B. Chanda, my name.
Mr. P. Hazarika, Learned Counsel appears for respondent number 5. List again
After 3 weeks, my lord.
on 24/6.
All right.
Yes, Mr. Saikia.
The petitioner has been, my lord, getting his all, has got the a year salary, but the gratuity was not given. Because on the ground that a CID case was registered at my lord page number.
CID case. So last time who appeared? Mr. J.K. Goswami was there. J.K. Goswami.
University CID case. My lord, that can you see, my lord, that an order of this court at page 26. Page 26, my lord. Paragraph, my lord, if relevant portion will be a paragraph. Paragraph 6, page 27. Having heard the learned counsel for the petitioner and learned counsel for the respondents, am inclined to dispose of this contempt petition by extending the period of time fixed in the order dated 7/1/2013 for its implementation by a further period of 3 months from today, as an outer limit provided no appeal is filed by the respondents and no stay is obtained of the order impugned therein. In other words, if no appeal is filed by the respondents and if filed and yet no stay is obtained, then the order dated 7/1/13 passed in WPC number 5456 of 12 shall have to be complied with in letter and spirit by the respondents within 3 months from the date of this order. In case if order is not complied with, even within the extended period of fixed by this court, subject to what is discussed above, the respondents and all other authorities responsible for ensuring compliance shall be held guilty for committing contempt of this court order, and appropriate orders imposing punishment as provided under the Contempt of Courts Act would be passed against each of them. The learned counsel for the respondents are requested to forward a copy of this order along with the copy of original order dated so and so, passed in WPC number so and so to the respondents. We have informed. Only they are taking the plea that the CID case number 7, they do not know. The university, it is a burden on the part of the university. Lordship, then I will kindly see, I have made an RPI to the my lord CID. I take answer.
Just a minute, Mr. Saikia. This
Annexer,
earlier, this matter was listed some other time, last time. So the government advocate was asked to get instructions regarding that CID case. Mr. J.K. Goswami appeared. Today is not here.
J.K. Goswami.
What is to be done?
Rejoinder Goswami.
Your basic prayer is only for release of the gratuity.
gratuity.
They say that because of CID case, they are not releasing.
My lord, Annexer 10 we visit.
Sorry?
The reply of the CID. Annexer 10.
You have shown me the other day. I've seen it
Respond.
already.
They are sitting tight. I do not know. And this petitioner is he is now 85 years old, lying on the bed. And other 2 persons have been already reinstated. And they have been given gratuity also.
Who will release this gratuity? Who's supposed to give you?
This gratuity is to be given by the Guwahati University.
Yes, Mr. Phukan, what do you say?
That direction, my lord, page 27.
Yes,
In the middle portion, my lord.
yes, middle portion.
Having regard to the aforesaid submission advanced. Para 4, my lord, last portion. Page 27.
Yes, I've read it. What about
My
this?
lord, relating to the payment of gratuity, the last sentence, my lord. The university authority shall consider payment of such amount as soon as the criminal proceeding is over. Other benefits have been given, my lord. The subsistence allowance as well as leave encasement, everything has been, my lord, given, my lord, way back in 2014. But regarding this criminal case, my lord, the university authority is still in dark, my lord.
How do you say it's in the dark?
My lord, since, my lord, he has been directed, the writ petitioner has been directed to present the status, my lord. What's the status of that CID case, my lord? But neither the university authority nor the writ petitioner seems to be, my lord.
The status is to be obtained by the university, my lord. I was an employee of the university.
My lord,
It is their burden.
the CID case has been lost by
The university is sitting tight.
no, my lord. Since, my lord, that CID case has been lodged against the writ petitioner. It has not been lodged by the university authority.
Who has lodged it?
That CID, my lord.
CID on what, under what section?
My lord, this.
What is the
last page-
allegation?
Last page, my lord.
What is the allegation? Last page?
Last but one,
Means?
29. The
420.
present status of the CID case number so and so under section 468, 420, 120B of IPC.
This I have submitted this letter to the
What is
director.
this?
So as per the earlier order, my lord, passed by this honorable court, Mr. J.K. Gusami is supposed to, my lord.
No, I
provide
understand
the-
that. Now this, what is this? RTI application?
Yes, my lord.
This is the application only, isn't it? This is not a reply.
An application filed by us. And
And then, my
What,
lord,
what is the reply?
on the reply, my lord, page number 30.
What do they say?
What they are telling, my lord, kindly see. This is to inform you that the CID organization is exempted from the purview of the RTI Act as per provision of section 24(4) of the Act. Height Government Assam Political Department, notification so and so. The IPO number so on is written here with. My lord, the university, my lord, I was their employee. What steps are taken by the university? Why they are sitting idle for last 25 years? While other two persons who were suspended, my lord, that kindly see that they have been reinstated and gratuity was given. My lord, the other two persons, my lord, page number.
My lord, the best course of action will be Mr. J.K. Goswami's presence should be required. my lord.
Exactly.
My
Where
lord,
is he?
otherwise, my
He has
lord,
not come.
Lord,
Has he not come?
JK Goswami, কি কথা দিও? Lord, another date may be fixed, my lord, day after tomorrow, my lord.
My lord, no, my lord, my humble prayer will be that if there is no case, that order may be passed. If there is no case, the university should release my gratuity. That
So
may be
let us
best.
get the information
As far
from,
as my knowledge goes, there is no case against me.
okay.
Other two accused persons who were also suspended, they are given the gratuity. And that order will help me.
We'll list again when?
Day after tomorrow, my lord.
Let it be tomorrow, my lord.
No.
Because my lord, this person, petitioner, I've been, my lord, on the bed, dying bed.
Or
Monday.
Monday, my lord.
We'll have it on Monday.
Monday,
Please inform Mr. Goswami.
my lord.
My lord, my humble prayer will be that if your lordship pass this order, that if there is no case, the university will release the allowances, this gratuity, that will do. Because I have my instruction is that
You
there is
please,
no case, there is
please,
no case against me.
please wait for some time. We'll pass that order definitely, but let us just hear Mr. Goswami when he comes, what he has to say about this case, okay?
Then my last chance may be given to them.
Peruse the order dated 19/5/2025. Stop, Mr. J.K. Goswami, learned senior government advocate, is not present today. List the matter again on Monday.
And this will be maybe my last chance, my lord. Kindly. My
We'll
lord,
see.
my humble prayer, this may be on that day, this may be disposed of, my lord. This
We'll
observation
see.
may be kindly
Let it
given.
come up again. We'll see.
My lord, observation may be kindly given. Otherwise, my lord, kindly see the case has been filed long back.
No, we're not giving any observation, Mr. Singh.
No, my lord, otherwise, my lord, on that day also, they will not bring in any any information.
Inside in radio.
Tomorrow, university can release money, no?
সোমবারে ঠিক করে দিন, sir.
You wait till Monday. Let's see what happens.
Because university also not making an attempt, not writing any letter to the CID. My lord, case has been registered in 2000.
Yes.
And other two persons can be see, they have been already given, this gratuity was given, my lord, who were also suspended along with me. I am a grateful employee, lordship. Grateful employee.
Wait for a few days. We'll see.
My lord, so that's why, my lord, I make a prayer that on that the case will be disposed of. Then they will come. So far, I have collected the information. The CID case already is dropped. It was the burden on the university to make the submission that there is no case now.
Most of it.
We'll see, Monday, huh?
I am tired, my lord, in this case, because for this poor man, I have come, and my lord, this amount is lying there with them, and they are bound to pay the interest also, because if the case has been dropped, so far my instructions are long back.
All right, we'll see.
May I please, Your Lord?
Hmm.
Lordship, this case is basically for non-release of arrears of compassionate family pension and other retirement benefit relating to the service of my father, Lordship. In this case, Lordship, notice was issued, Lordship, and Lordship may kindly come to the page number, Lordship, 29 of the writ petition, Lordship. This is a very simple case, Lordship. Case was returned back by the Accountant General with some observation, Lordship. If having regard to the observations, pension papers are resubmitted before the Accountant General, my case will be finalized, Lordship. That has not been done by the authority, Lordship. Page 29.
Secondary.
Yes, anyone appearing?
Lordship,
Hmm.
Lordship, instructions are awaited, Your Lordship.
Hmm.
Because
Which respondent?
Lordship, I am for respond number 4. Yes. One.
Director of Secondary Education.
Lordship, the annexure that has been referred by the petitioner, Your Lordship. Page 29, Your Lordship. It is to the Commissioner Secretary to the Government of Assam, Your Lordship. So it is respondent number 1. Respondent number 1. Your Lordship.
You're for number 1.
1 and 4, Your Lordship.
See, petition was filed in 2023.
Lordship.
You should have filed your affidavit by now.
Lordship, he was initially appointed as the adult education officer, Your Lordship, and that post was phased out, Your Lordship. And so before being absorbed, before being regularized in any post, he was working as a DEO from 2001 to 2009, Your Lordship.
All right, but can we take can we put that on record, all these things? Unless you file something.
Lordship, here the elementary education is also they also have to reply, Your Lordship. In this
matter, I've got my instructions, brother. In this connection, my lord, before the reorganization of the Department of School Education, the order of posting and transfer of DEOs has been issued by the Secondary Education Department. My instructions are that it is the Secondary Education Department who is the appropriate authority.
And this communication was also to the secondary
And
education.
it has been, well, this is 27 May to this period.
Secondary Education Department is a party also.
Lordship.
They are a party, so they are the necessary party.
They are a party already. They are respondent number 2.
The respondent number
And also number 4. Director and secretaries that are there.
1 and 4, Your Lord.
So what do you want to do? Instruction,
Lordship will,
affidavit.
Lordship, I'll place the instructions, Lordship.
Hmm?
Instructions, Your Lordship. Lordship will give us,
You file your affidavit.
Lordship, then 3 weeks' time, Your Lordship.
I also bring this on record, see.
That is the normal rule, isn't it? Otherwise, they'll also orally submit. This is my prayer, give me. You'll also orally submit, give me. Then there's no concept of file and all this thing.
So Lordship is a.
He has submitted his pleadings by way of writ petition.
Lordship,
It's a duty to file a counter affidavit, whether you reject it or accept it or whatever.
because it's a pension matter, Your Lordship, so maybe.
And Lordship, there are, Lordship, only some period has to be regularized, Lordship. Gap period of services.
2001 to
As
2000.
paid for further 3 weeks time is granted to the response to come up with their affidavit in opposition.
That may be fixed, Lordship.
List again on so and so.
Obligation.
Obligation.
Lord, I appear for respondent number 7. Company. D. Bhattacharya, respondent. Okay.
22 and 23.
Item number 23. This is for regularization of the service of the petitioners who are working for more than 32 years. Now, there is a judgment by the Apex Court, 2025. I have given a copy, member. In view of the judgment, they are entitled to an last.
Working as what?
Hello?
Working as what?
They're working on contractual basis. Now they are getting some work charge.
Contractual basis. They are teachers. What are they?
They are
Laborers.
section assistant.
Section assistant.
You're
Where?
looking- You see page 18.
Under whom? Under which establishment?
PWD. First page 18, your lordship, can you see page 18? This is a first appointment order in the year 1990,
Why these two writ petitions? This similar matter.
similar matter. One PHE, one PWD, man.
They are working as
Section assistant,
section assistant. Work charge.
work charge, colors. Page 18, my lord, petitioner is Prosenjit Haflangwar, he is number 1. Others are your lordship will can be things and persons who were appointed with them at page, my lord, serial number 2, 3, 4, 5.
Hmm.
Lordship got it. Page 20, your lordship can see they have been regularized. Regular cadre. This item number, petitioner number, the person at serial number 2, 3, 4, 5, they are at my lord, serial number 17, 19, 16 and 18. At page 220.
When was this?
This was in 2006.
Then why are you coming now in 2023?
No, this was, these persons, they do not know about what is happening in the department.
Things must have changed by now.
Yes.
Situation may have changed.
It's so persons, my lord, they are still in service. Now they are.
Pilot 5, they are also pilot reading the order. I will matter for hearing matter. Distribution of hearing. I will speak to judgment.
You are for which respondent? PWD.
Similar matter, my lord, coordinate bench recently passed order, my lord. Because the matter of petition 117 of 2017. The judgment was passed on, my lord, on 22/8/24.
This pertains to NC Hills also.
This is NCLs, my lord. NCLs.
Regular.
With the highlight condition.
Lordship, regarding item number 22, our affidavit is ready and we have sent it for vetting. We'll file it next week, Lordship. So kindly accommodate us.
22.
22,
Okay.
regarding item number 22. And for respondent number 4, 5 and 6, Lordship.
4, 5, 6.
Lordship. We have sent it for vetting, Lordship.
Well, let government file affidavit. They have not filed affidavit as yet. And my lord, let them file affidavit.
All
My
right.
lordship will fix the matter on a particular date.
Mr. B.D. Das, Lanet Senior Counsel, assisted by Mr.
HR.
H.R. Das for the petitioners who submits that by filing this,
Two matters don't fix up.
these, HESE, these with petitions. The petitioners
But we must keep it nicely.
seek for regularization of the service.
Defenders case is there, vendor case is there. What should be there?
Similar to Rathai Regularization service. Stop the learned senior counsel submits that the petitioners have been working more than 30 years as work charge section assistant. And similarly placed persons have already been regularized.
And also in view of the Supreme Court judgment, my lord, I am entitled to be regularized.
Learned senior counsel has also relied upon the apex court decision in
Two judgments.
Sripal and another versus Nagar Nigam, Ghaziabad. Reported in 2025 0 INSC 144. No, cancel that. Reported in 2025 3 Supreme 17. Mr. Ardhar, learned counsel appearing for the Public Works Department, submits that he may be given some time to prepare the matter. Ms. J. Rong PP.
S. Capri, Lordship.
Mr. S. Capri, learned counsel appearing for respondent numbers
4, 5, and 6.
4, 5, and 6 in WPC number
WPC number 3517.
3517 of 2023 submits that the affidavit has been sent for vetting and she'll be able to file the same within the next 1 week in view of above. Let the matter be listed. Let these matters be listed on so and so. 17-7. You are there?
17.
I am item number 23, that's for 5.
Mr. C. Sharma, last learned counsel appears for respondent number 5.
17-7.
Yes. WPC number.
Affidavit has been filed.
Sorry.
Item 22.
Respondent number 5 in WPC number 3624 of 2025 or 2023.
17-7, both cases.
Both cases. They're together, that's why.
They're together.
Mm.
Obliged.
Great piece of lordship. Lordship, the petitioner is working as an assistant teacher in Sangsari Adarsha High School. Lordship, since 7th of June 2024, Lordship. On 11th of August 2023, Lordship, an order was passed by the Inspector of Schools, Aminga, Lordship, directing the transfer of the petitioner from Changsari Adarsha Higher Secondary School to Bongshar Higher Secondary School within the same district, Lordship. Lordship, the Honorable Court was pleased to grant an interim order stating that transfer order on 2 grounds, Lordship. Firstly, on the basis of rationalization, Lordship, the PTR ratio of the present school is higher than the PTR ratio of the school which he ought to have been transferred, Lordship. And secondly, on the ground that this the junior most teacher needs to be transferred, not the senior teacher's, Lordship. Being in the intermediate level, Lordship, the junior most teacher ought to have been transferred, Lordship. On these 2 grounds, Lordship, interim was granted, Lordship.
Lordship, here also the instructions are awaited, your lordship.
What is the interim order passed?
Lordship, interim order was first passed on 22nd of August 2023, Lordship. That status quo needs to be maintained, Lordship, in paragraph number 11, Lordship. And it was clarified on 29th of August 2023, Lordship.
This is regarding transfer.
Yes,
Transfer.
Lordship.
Hmm. All right, then you file your affidavit.
Lordship.
As paid for by Miss
D. Musahari,
D. Musari, learned counsel appearing for the
Secondary Education.
Secondary Education Department. Further 3 weeks time is granted to file counter affidavit. Miss Arborova, learned counsel appears for the petitioner. The interim order passed earlier shall continue till the next date of listing.
Obliged. Lordship, 25/6, I have some difficulty, Lordship. Any other day, like before 25/6, Lordship. Possibly. Or it's after vacation. Lordship. 16 June.
16/6. 16/7. huh?
May please, your lordship.
Yes, Mr. Siddharth.
Here, in this case, my lord, we have challenged the provincialization of the private respondent number 7.
Mm.
My lord, by the impugned order, and there was an order of the Honorable Court remanding matter for consideration by the authorities, but they have rejected the case, my lord, by impugned order at page 99. But my lord, the matters requires some length of hearing,
So we'll have it some other day.
my lord.
You are challenging the
Yes, ma'am.
provincialization of the private respondent.
And the subsequent order whereby my case is
But why?
again rejected.
This is IA.
Mine is the IML.
IA is for?
But they paid for some interim order that they may be paid salary, my lord. When the appointment is illegal, that has been suspended. My lord, the court has not considered the interim order. It may be better heard together.
My lord, only thing I'll, if your lordship appreciates one thing, my lord. What my friend is saying, rightly or wrongly, for argument's sake, but actually rightly, the petitioner doesn't have any right for this writ. But I have been provincialized, I am working, but I have not been paying salary money.
Since when?
Since my provincialization.
When is that?
If my lord,
My lord-
if my lord salary is paid, then my case will be infructuous, my lord.
Why?
But his appointment is itself is illegal, my lord.
No, your
In violation of the
provincialization.
law, my.
When was your provincialization?
My lord, provincialization was 5 February 2021. With
21.
effect from 1/1/2021. It's like, my lord, I'm starving, my lord.
My lord,
For so many years after that, my service was provincialized. That's what the reason I'm saying, rightly or wrongly, but I've been provincialized, I'm working. My friend yet to succeed in the case, then his provincialization will come. And obviously from the day, if he succeeds, from the day he's provincialized,
Okay,
he'll get a salary.
Please agree to a date, then we'll fix a date. So that we can hear the sort of the matter. Please write down.
My lord, on 3rd.
Legality or otherwise of the provincialization of the parties, of the private respondent.
my lord,
Is
my
the,
lord, any other date, my lord.
if the issue raised in the instant writ petition. Most of the parties are represented by the respective councils and they express urgency in the matter.
Very well.
In view of above, list this matter on so and so. When?
My lord, not on 3rd, my lord. I have some other.
My lord, then 10th.
10th the problem.
10th is a Tuesday, my lord.
Yes, that can be.
It will be better, my lord, for admission hearing.
12th of June?
Yes, my lord.
All right, 12th of June.
12th of June.
Yes.
My lord, only one thing, if your lordship, endeavor will be made for disposal, my lord.
All right. I've already indicated
Right.
urgency has
Yes,
been expressed.
It-
Yes.
Deep lovely.
May I please, your lordship?
Yes.
My lord, matter relates to appointment of my lord assistant professor in the Department of Commerce, Guru Charan College. Now, my lord, in the selection, the name of the petitioner has been selected in the top of the merit list. Then, my lord, the selection committee followed the name of the higher education, my lord, director of higher education, my lord. But this appointed the second position, my lord, the private respondent, and not appointed the petitioner, my lord, who is in the top of the merit list. Lordship, may kindly see page 72. About page 71.
Lordship, we need some time to file affidavit, Lordship.
You have not filed.
No, Lordship.
3 and 4 has filed.
Lord, I have filed on behalf of the college.
3 and 4.
Respondent number 3 and 4.
Okay, who is the other respondent?
My lord, the director higher education, my lord.
And private respondent is also there. Private respondents.
Mr. Dasgupta is for.
Please write, parties are represented by the respective councils. List of respondent number 3 and 4 has filed counter affidavit. And the private respondent number 5. Respondent number 5.
No, my lord, 6. Private
Private-
respondent is 6, my lord.
Private respondent number 6, being represented by Mr. A. Das Gupta, learned senior counsel, submits that the respondent numbers, the affidavit of respondent number 3 and 4 will be relied upon by the respondent number 6 without filing a separate affidavit. Then Mr.
A.R. Tohavil.
A. Tahivildar, learned counsel, appearing for the
Respondent 1 and 2.
respondent number 1 and 2. Praise for and is granted. How much time?
3 weeks.
3 weeks time.
Kindly fix a date, my lord.
3 weeks time to file counter affidavit. Stop, since the urgency has been expressed by the learned counsel for the petitioner, that the matter be listed again on so and so. 26/6.
Obliged.
All right. Mr. Datta, I'll record your name also.
Oh, yes.
Mr. S. Datta, learned senior counsel, appears for respondent numbers 3 and 4.
Obliged.
I am praying for disposal of the matter in terms of the order passed by the division bench. I've given a copy to her.
Lordship is a different matter, my lord. The developments.
That's all. My lord, the petitioners, they were appointed as a master road worker in the year 1993. That is at page 19. And
This is regarding regularization,
no. This is regarding promotion, ma'am.
promotion.
Promotion because they
From
were,
which,
they were.
from which post to
appointed-
which post?
They were appointed as in a personal post. So there is a division bench judgment of this court, Taludar's case, where it says if somebody is appointed in a personal post, then one cannot be considered for promotion.
Hmm.
So, but one can pray for encadrement. One can pray for encadrement. So
While still in service.
he is still in service, so one can pray for
Encadrement to what? Regular cadre.
regular cadre, yes. So therefore, my lord,
There's a provision for that.
there is a provision for that, and there is a, in similar, no, that order is there, no? And there, I was given a copy of the order yesterday. Yes. Yesterday, where the government has encadred some persons. I'm just giving a copy only. Now, because of that provision, my lord, and because of the division bench judgment, some persons have been encadred. Where is the division bench judgment?
Our department or his,
Alike department, government of which? Some. Now, in this case, PH ने की बात है वो होगा. PWD. Road. Will you take this case? Will you take the case? How do I give it to the court? There is a provision for encadrement, my lord, they do that. What did you give?
my lord, that Talukdar's case, your lordship will kindly see, para 12. For me. Para 12. May I just read it?
Yes.
We have seen the reasons recorded by the learned judge for the impugned verdict and find that the post against which the petitioners were regularized were never added to the notified cadre in the department. Yet no plea was advanced for encadrement of the post held by the affected parties. Therefore, the promotion in the department can be considered only from the eligible employees in the feeder cadre, and the writ petitioner being outside the cadre cannot have any enforceable right to claim promotion, particularly when the regularization order itself stipulates that they are regularized in post personal to them. Such temporary creation of posts cannot automatically add to the cadre strength of the department, and claim for promotion from a person holding an ex-cadre post is not legally feasible. So it says, Malad, if you are appointed in a personal post, you cannot be promoted unless the government encadres. So the Malad, in this case, Malad, your lordship will kindly see page 23. Page 23. The
Which case?
petition 23, Malad.
Which case? Yeah.
1513.
23.
Yes, the person and these petitioners were regularized will be personal to the incumbent. Where is my name?
Yes.
Yes, personal to the incumbent. So this was a order of appointment, regularization. So ultimately, my lord.
These are the petitioners.
My lord, yes.
These are the petitioners.
Petitioner, yes, petition number 1. Manoj Diwanji is there, serial number 5.
He's the lone petitioner or what?
My lord, no, here's your loan petition. Others may have been promoted, I don't know, my lord, but they.
So if the creation of posts for regularization is only personal,
Person,
then
that means
how?
unless you are encadred,
uh,
you cannot be promoted.
correct. So
But I'm coming, but in this case, my lord, what has happened? Government, my lord, your lordship will kindly see page 52.
mm, yes, 52.
Many similarly situated persons have been, page 52, your lordship is subject to reversion without notice and assigning any reason thereof. The following grade 4 personnel are hereby promoted to the post of section assistant so and so plus usual allowances. The incumbents are directed to join in the so and so. All these persons were working as a in personal post. Similarly, my lord, so we came before this court and court directed to consider our case, page 54. These persons were also in personal post, and I'll come, there are more persons are there. These are from the inland water department, the department concerned. I've given statement that these persons were also a statement, were working in a personal post. Now, we came to a High Court, page 54.
Mm.
High Court is directed to consider. May I read page 55 now?
Yes, I've read it.
Yes. So in view of that, my lord, now legal reply comes, page 57. I would like to submit herewith a copy of the judgment and order dated so and so. That is the Talukdar's case, wherein mentioned at point 11, number 11, that ex-cadre incumbents holding posts on personal basis found to be untenable for promotion.
Mm.
So that is the Talukdar's case.
Mm.
I have sworn, my lord. Now I have given this order of promotion, page 10, page 58, your lordship will kindly see.
Mm.
order of promotions of 25 numbers of grade 4 employees working in personal post. They have been promoted, page 58, page 61, and page 63 onwards, my lord. All together I have given about 50, 60, 75, 85 persons at serial number annexure 10.
All right, but
11, 12.
they may have been,
They have been promoted.
they may have been promoted, but
Yes.
is there a provision as such?
No, there is no, that's what I'm coming, my lord. So therefore, my lord, when similarly situated for, my lord, case came before the honorable single judge dismissed it, and we came before the writ appeal. Writ appeal's order, your lordship will can see. Writ appeal says that you you consider encadrement.
Where's the writ appeal order?
So that consideration is similar, that's what I'm saying, my lord, similar order has to be passed in this case also. Encadrement and policy direct department.
This is appeal against which order?
Against my lord, order passed by honorable justice.
Where's the order?
Well, that order is not there. Huh? Justice Michael. Huh? Huh? That judgment we did not bring, my lord, that order is. That judgment passes similar order that since you are appointed in personal department, personnel post, so you will not be, you are not in a position to consider for appointment, for promotion.
এটা তো স্যার এক্স ক্যাডার পোস্টে ক্রিয়েট করেছে এক্স ক্যাডার পোস্টে ক্রিয়েট করেছে
Which person?
এক্স ক্যাডার পোস্ট ক্রিয়েশন অফ এক্স ক্যাডার পোস্ট তো না হয় এন ক্যাডার করা কোথায় করছে
পড়া নাই কেন?
ফটো কই দিও না মিস্টেক করা
No, my lord.
You want an observation?
Similar orders, my lord, that no bar for consideration for encadres. My lord, that order which I have given, my lord, consideration of encadrement, I think some mistake on my part.
It's a creation of ex cadre
Creation of
post
ex-cadre
regarding,
post.
not the encadrement of post.
Hmm.
The
So recommendation-
letter they referred by my senior is the creation of ex cadre post, not the
This-
conversion of ex cadre to encadre. The recent
That your
notification.
lordship may ignore, ma'am. Recommendation for creating ex-
Creation of
like
ex cadre.
creating ex further post. Creation of ex cadre. So
But
I,
I had asked you regarding that, is there any provision for encadrement?
yes, encadrement, my lord, learned division bench has already mentioned.
No,
Yeah.
mentioned because it was prayed before that court
No,
that we have already applied for.
no, not that.
See, let me read for you.
Lordship, that lordship will get the answer at page 78 of my.
Just a minute, let me clarify this thing. Learned counsel for the appellants submit that after passing of the impleading order, appellants have already approached the state government with a prayer for encadrement
Yes.
of their posts, and their prayer is pending consideration. Therefore, court may observe that dismissal of the writ petition filed by the appellants will not affect the rights of the appellants for consideration of the prayer of encadrement. So this is their own doing. It is not that there is already a standing policy or something like that for encadrement.
No, they.
Person has applied for it.
Applied for it.
Said, although my writ petition is dismissed, let it not be a bar
Yes.
to consider.
That's,
That observation we want. So
Yes.
that was given to them.
yes.
So what stops you from applying for encadrement? This,
Applied for,
where is that?
they have to consider it. Representation is at page 70.
70.
No? We have applied for.
Petitioner's has been
Service. Page
has been
70.
appointed as master role
Yes.
since 1991.
Same.
And the other one,
The other one is also fallacy.
master role
No, they are regularized. Regular khalasi, work as khalasi.
Oh, this is for promotion, isn't it?
Yes,
Yes.
because since 2004.
Both the petitioners are work
Yes.
charge khalasi
Yes,
who have been regularized.
yes.
And now what is the next promotional post? SA,
Section assistant.
section assistant.
Section 6. This is
Where is your representation for
page 70.
70?
Because since 2020 years, they have been serving in the same post. So some and similarly situated persons, rightly or wrongly, they have been promoted.
So you want an order from this court to direct the respondents to consider your representation
Presentation for
In-
Encadrement
for encadrement.
and for further consideration for promotion on the basis of the similarly situated.
Lordship, I have
persons.
objection, my lord, because of course, Lordship may kindly have a look, the projection made by my learned senior. Page number 52. The learned senior stated that these are the all person whose service was regularized under personal post, but this not. Lordship, page
52.
52. May I read, my lord?
Yes.
Space 52, order dated 27th of February 2014, my lord. Subject to reversion without notice and assigning any region thereof, the following grade 4 personnel, not personal posts, the grade 4 personnel are hereby promoted to such and such. So these are not regularized under personal post. The petitioner is regularized under personal post, lordship. And regarding that, this is the second round of litigation, my lord. In the first round, this honorable court has directed us to consider their case, and we have considered his case.
What is the first round order?
First round order, my lord, we find in the petition itself,
Page number.
This is page 54.
54, my lord. 54, relevant 55, my lord. Lordship had got in, my lord.
So what have you done?
We have considered their case. Lordship may kindly have a look, my affidavit. The minutes I have annexed.
No, any document, they have submitted representation. Have
Lordship,
you?
for that, lordship, that paragraph 8 we have mentioned, page 478. Page 78 of my affidavit, my lord. Paragraph 8. They said they have submitted some representation way back in the year 2022, and we have filed the affidavit in the year 2024, and there is no such seal and signature that we have received their representation, although that paragraph 8 is reflected, my lord. Page 78, my lord.
No, that's, you say there's no rule as such.
Yes, there is no
But
rule as such.
What I asked you was regarding their representation, because the first round court says that you may consider.
Yes, then we have considered.
How? When?
I have annexed page 87, the last page of my affidavit. 87, my lord.
Yes, read.
May I read, my lord?
Yes.
The Departmental Promotion Committee has considered the name of Sri Rupa Devanji and Sri Manoj Devanji. They both are the petitioner, my lord, here.
Yes.
And the Khalasi and Sri Sasensa, some other person also, in terms of the direction issued by the Honorable Guwahati High Court order dated 15/3/2023 in WC number Sasensas, Rupa Devanji versus State of Assam, and order dated Sasensas, Manoj Devanji versus State of Assam, and order dated Sasensas. The name of Sri Rupa Devanji, Sri Manoj Devanji, and Sanjeev Dev Purkasto were considered by the Departmental Promotion Committee. However, upon examination, the names of Sri Rupa Devanji, Sri Manoj Devanji, and Sri Sanjeev Kumar Dev Purkasto was not recommended in terms of the judgment and order dated 10/2/2017, passed in the Honorable Guwahati High Court in writ table number 124/2015, the lead talukdar case, lordship. So we could not consider because they were regularized under a personal post. And at present, there is no rules the conversion of a ex-cadre to an encadre. In the year 2004 itself, lordship, they have been regularized, and they have not raised any issue at that point of time. Now they want their promotion.
You have rejected their plea on the ground that
Yes, madam.
because of Dilip Talukdar's case.
And also para 8. At present, there is no such rules regulation to conversion of a ex-cadre to encadre. Paragraph 8.
Mr. Das, have you noticed this Talukdar's case,
Yes,
the quorum?
Yes.
yes. Well, the Talukdar say, case says, my lord, the petitioner persons who are appointed in a personal post, they are not entitled to be considered for regular, for further promotion.
Ah.
One can, if you go for encadrement, if the order is there for consideration, if they're encadred in the post, then thereafter government may consider for promotion. So in that Talukdar's case, it is noted that there is no prayer for any encadrement. So therefore, we came before the division bench. Division bench says, my lord, that you consider them for encadrement. You may reject it. The person appointed in personal post, my lord, they have promoted, my lord.
No,
I'll come to that, my lord.
Dilip Talukdar is also for encadrement only.
Yes, my lord.
Yes,
Encadrement.
yes. No,
So-
Dilip Talukdar was for promotion.
Promotion to.
But because they were appointed in personal post, it was not done. My lord, I'm sorry, my lord, in this, now I'm not in a position.
No, what I was saying was something else.
Yes,
This judgment was passed by His Lordship Rishikesh Roy
Yes.
and myself sitting division bench.
yes.
So will it not be slightly difficult?
Doesn't depart, my lord, your lordship, because that judgment kept open regarding the encadrement, and therefore the division bench has passed the order. Division bench has passed the order, my lord, saying that you consider irrespective. of the
This was for
judgment.
promotion,
Yes.
not for,
No.
not for encadrement.
Promotion from ex-cadre person.
Hmm.
They are not entitled.
Yes, that order, that judgment, Dilip Talukdar is that.
But
for
this
promotion.
division bench order also does not say anything much.
Yes,
Not much.
lordship.
For
Because
consideration
that
of the
department,
encadrement.
as per the.
For
last
consideration of the encadrement.
No, lordship, there is no, they have already filed application and they have stated some person has already been promoted in that department. In our department, we have affidavit. We don't know, as per our affidavit, at present, there is no such rule from shifting of ex-cadre to encadre. And the notification, recent notification that my learned senior has placed before my lord is regarding creation of ex-cadre post.
My lord, your lordship will kindly say page 58. Page 58. This is in respect of the PHE, Public Health Department. Has your lordship got it?
I don't know. The lordship may grant me some time. I will get instruction from the department whether other department has taken any initiative regarding
Not only
the
that, but in
conversion of
that-
ex-cadre to
in-
encadre post.
No. In their department itself, persons who are promoted, who are appointed in a personal post have been appointed. I'll show it. Have been promoted. Page 58, your lordship got it, man.
Just a minute.
Yes, sir.
One thing appears to be the fact that rejection of the presentation is on the ground of was regarding promotion, not encadrement.
Lordship.
That subject of encadrement has not been touched, it seems.
Well,
Because-
therefore, Lordship may grant me
because-
some time. I will get instruction from the department.
Ms.
whether-
Bora,
Lordship,
just have a look.
Dilip Talukdar case, my lord.
No, at page 55 of the writ petition. Earlier round, the first case, it says that the petition is disposed of providing that the case of the petitioner for promotion to the rank of so-and-so be considered in accordance with law. It merely speaks about promotion.
Yes, promotion.
And Dilip Talukdar says that if it's ex-cadre, not possible.
That's why, Lordship, the
Now they say that please encadre us. So that encadrement prayer has not been considered. it
because
seems.
paragraph 8, Lordship, we have stated our affidavit. At present, there is no rules regulation for shifting the ex-cadre post to encadre one.
Correct, but there's no bar for you to consider. You may reject it, you may allow it, we don't know.
We have rejected, that's why we.
No, you have rejected promotion.
They may file a representation before the appropriate authority.
That's what, no? Let them file and let them consider.
We have already
If-
filed.
That, Lordship,
Yes,
we
sir.
don't know whether they have received or not in our year 2022. There is no seal and signature received.
So let them
Yeah.
file a separate,
Fresh.
file a fresh one.
Fresh for
Along
the
with the
authority.
petition we have filed and other also.
You file a fresh representation.
The fresh, they will consider if it is there.
Beyond that, what can be done? I don't think there's anything
Yes, yes. Because
possible because
if the looter
at the
gets-
outset, I had asked whether there's any such formula. There's no formula as such,
Yes, yes.
but at the same time, there's no bar as such also. So it,
Would kindly say, IWT also I can show there are persons who have been promoted or who are who were appointed in personal post. But now I am unable, but page 58 you also will kindly see, page 58. It is for the benefit of the department because these persons are working for last since 20 years.
This is some other
Page
department.
58 has a also got it.
yes,
The department, not the
Yes, other
identity.
department, PHE department, here lots will be a promotion from personnel post. It is not that they are not promoting.
Lordship,
If the posts
petitioner may
are
file a
vacant,
fresh
if the
application.
posts are vacant, but it is liable to be considered, my lord. Then,
what is this communication?
which one, my lord?
58, which you just showed me.
58 is a, I'm showing the promotion orders in respect of.
Correct,
persons.
but it is written from the deputy secretary to the chief engineer.
Yes. From deputy secretary to the chief engineer.
Concurs the
With the-
proposal.
Directed to inform him that the finance department has concurs to the proposal for promotion of the following post under the Dhubri PH division and poster male like this, promoted
All
from
right.
personnel post. Promoted from personnel, has a lordship got it?
We'll do one thing, then we'll ask you to file your representation
Yes, Lordship.
and let them consider it.
And also we have filed representation at page 17.
Heard Mr. B.D. Das, Lanet Senior Counsel, assisted by Mr. J. Lotha for the petitioners.
Oh.
Stop also heard Ms. M.D. Bora, Lanet Standing Counsel,
Department.
Standing Counsel Transport Department,
Respondent number 1, 2, 3, and 4, my lord.
appearing for respondent numbers 1, 2, 3, and 4, and Mr. A. Chaliha, Lanet Finance, Standing Counsel Finance Department, appearing for.
My lord, may I just, one second, page 26, your lordship will can see. This is from Inland Water Department.
Yes.
These persons are promoted in.
This is it. This is declaration order.
Yes, appointment order in personnel post. Serial number 14, your lordship will kindly see, and serial number 17. Your lordship may kindly see Islamuddin Lahkar and Habibur Rahman. As your lordship got it. Serial number 17 and serial number 14. As your lordship got it.
Yes, how, what about them?
Yes, they are all appointed in my lord in a personnel post. Now serial page 58, your lordship will kindly, this is Inland Water Department. 52. Has your lordship got it?
Yes.
These persons are promoted in the year 2014.
Okay.
These two persons.
We'll see.
Serial number 14 and serial number 14. Inland Water.
We'll see. Mr. A. Chaliha, Lanet Standing Counsel Finance Department, appearing for respondent number 5. Stop having regard to the nature of grievance projected by the petitioners. The writ petition is taken up for disposal with the consent of the parties. Stop. This is the second time
Yes.
for only one of them or both of them. Second
Both of
time the petitioners are before this court. Stop the earlier writ petition. being WPC number 550 of 2023. What about the other case? Where is the
369 2023. Is it
And-
Rupa Devanji?
and 1-3
Lordship, 89.
case number?
7 of my affidavit.
No, in respect of Rupa Devanji,
Yes.
what is the case number?
1389 2023.
Okay. Being 550 of 2023 and 1389 of 2023
Lordship.
was disposed of by this court. With an observation that the case of the petitioners be considered for promotion to the rank of section assistant in accordance with law. To stop, be it stated herein that the petitioners have been initially appointed as work charge. What? Work charge what? Khalasi. And were later on regularized in service
In the year 2004.
in the year 2004. The appointment of the petitioner. Now, the regularization of the petitioner is in a personal post. So, however, after the disposal of their earlier writ petitions, their claim for promotion was rejected on the ground that they were holding personal posts, which was an ex-cadre post, and therefore not permissible, and therefore they were not eligible to be promoted to higher posts. Stop reference to the case of Dilip Talukdar and others versus State of Assam and others, reported in 2017, 3 GLR 376 was made by the respondent authorities. Stop. Mr. B.T. Das, Lanet Senior Counsel, submits that similarly situated persons under the establishment of Director, Inland Water Transport,
Islamuddin Laukar and
had been given the benefit of promotion, although working in personal post.
Lord,
And
this regulation order, there's Malani Senior has relied, my lord, page 52 is order dated 27th of February 2014. Dilip Talukdar came,
promotion order.
it was passed on
Promotion order,
10
February.
This is the case order. Yes, it was passed on.
Ms. Bora, you
Lordship.
take it easy. We are asking only a representation to be considered.
Then
And likewise, even in the Public Health Engineering Department, a number of similarly situated persons working in personal posts have also been regularized, have also been promoted.
The year 2014.
PHE 22, 2022, after obtaining the concurrence from the Finance Department. Full stop. He submits that the petitioners have also submitted their representation on 9/2/2024 for encadring their service as a grade 4 cadre post, but the same has not been considered till date. Stop. As such, the petitioners are again before this court. Stop referring to the no, cancel that. The learned senior counsel further submits that similarly situated persons had approached situated persons being aggrieved with the rejection of their candidature for promotion to the next higher post on ground of holding ex-cadre posts had approached a division bench of this court through writ appeal number 5 of 2024. Open bracket, Nibon Chandra Das and 27 others versus State of Assam and 8 others, close bracket. Stop. The writ appeal was disposed of by order dated 14/5/2025. With an observation that the dismissal of the writ petition filed by the writ appellants would not be a bar for considering their application oblique representation for encadrement of the post which they are holding so as to get the benefit of promotion. To stop, the learned senior counsel submits that in Dilip Talukdar and others Supra, what was being considered was promotion to the higher post by an employee holding ex-cadre post. Stop. However, in the present case, the petitioners are seeking their encadrement to the gathered posts so as to get the benefit of further promotion to the post of section assistant under the transport department. Stop. He therefore submits that the respondents may be directed to consider the petitioners for encadrement so that they can be promoted to the next higher post. Stop. next para. It is seen that although the petitioners had submitted their representation for an encadrement of their service, as a grade 4 cadre post, but the same has not been considered. To stop the rejection of the prayer of the petitioners as can be seen from the minutes of the DPC dated 19/11/2024, annexed as Annexure 1 to the Affidavit of Position of the respondent number 3, goes to show that such rejection was on the basis of the decision made in Dilip Talukdar and others, Supra. Stop. As already stated, Dilip Talukdar and others, Supra, was in respect of rejection of the claim for promotion on ground of being an ex-cadre post. Unlike the present claim that they should be encadred to a cadre post. To stop such being the position, keeping in mind what has been observed in Nibon Chandra Das and 27 others, Supra, the petitioners are given liberty to file their representation for encadrement before which respondent?
Respondent number Lordship. 3 is, I think, director.
2 and 3, man.
Lordship, may only 2 is not the commissioner, not the director, my lord. The grade 4 employee is under the directorate, my lord. Director.
Before the
Respondent number 3. Director, IW.
Director, Inland Water Transport,
Lordship.
bracket, respondent number 3. What did I say? So as to enable them seek further promotion, seek promotion to the next higher post. Post up in the event such representation is filed, 'within
We'll file
Fif-
it immediately.
15 days,
Yes.
15 days from today, the respondent number 3 shall consider the same in the right earnest, keeping in mind the benefit of promotion having been extended to similarly placed employees in the past.
Lordship, that Lordship may not observe that line, Lordship, because at present I am not aware, because the regulation promotion of year 2014, my lord. The developer came in the 2017. Lordship may not observe that line. Lordship may kindly observe the representation.
She is very careful, I don't know. Huh?
Similarly, persons who were
Because
appointed
Lordship
with us,
have to follow.
the Lordship will kindly see the page.
Lordship, the
Yeah.
department will dispose of the representation considering all the
Similarly
aspects.
situated, yes. Similarly situated persons have been, persons who were appointed, regularized with the petitioners, my lord, they have been given permission.
Yeah, documents are there, which
Nearly
They will give
2014. And this case
Maybe.
came in 17. And
No.
they should have made them a party respondent here.
Why should
They did not make the party respondent.
no,
here.
why should they make them a party?
The Lordship may kindly, my lord may kindly observe that they may
What did I
consider
say?
all the
Okay,
aspects.
what did I say? Okay, keep in mind Khattai Zimero. Okay, cancel.
Lordship, deeply obliged, my lord.
Mm, and take a decision in the matter by taking into account all aspects of the matter as raised by the petitioner. Stop the exercise shall be done within a period of
2 months.
2 months from the date of receipt of the representation.
My lord, instead of director, IAWD, respondent note 2 and 3 may be.
Lordship, kindly
Director
direct
must be
the
the
three.
correct person.
There is a grade for employee staff, Lordship, and directorate is the authority, not the
It is
department.
okay, ma'am.
They will take the consent from the other stakeholder, also finance and from other department. She will take a call, he or she, the
He
director.
is not the only authority.
Lordship,
director is
director,
the-
Lordship may kindly.
Respondent authority, your lordship may can. May not, because I'm showing because the director may not be the sole authority to decide the matter. So respondent number 2 and 3.
Lordship may kindly record
I leave it to
three.
your lordship.
No, somebody will has to dispose it off. Who will dispose it off?
Three.
He may not, I don't think he's competent authority to consider to consider this encadrement. It has to go to the higher order.
So we'll have one more observation.
Yes, 2, 3.
It is further provided in here that if the respondent number 3 requires to take the approval from the Commissioner of Transport or Secretary.
Secretary Transport, Lordship, and Secretary Finance also.
We gave the concurrence. Should may reflect the respondents to be so that.
She will dispose of the representation, Lordship, and she will take in consent
You
from
will
order.
always-
She will do that, Lordship, that I will assure to the my lord. Because a grade for employee, Lordship, is under the directorate.
Representation डाल दो.
If the consultation of any other authorities is required to enable the respondent number 3 to dispose of the representation, liberty, no. Mm, What can be said?
Lordship, may direct the three, Lordship.
As may
They
be
will-
desired, as may be necessary.
please rewrite again, in order to dispose of the representations submitted by the petitioners as directed in here, in above, the respondent number 3, isn't it?
3.
May
May take up the matter with,
may
Because this earlier order also, which my learned senior is relying for the promotion, it has been passed by the director only, Lordship, respondent number 3.
no, that's right. But in order for going to
yes, but you will not consider.
With consultation with the other respondent, Lordship may kindly
May
observe.
consult, may take, may
May take up the matter.
may take up the matter with any other authorities that may be found necessary. All right.
Deeply obliged, Lordship. Similar order may be passed in the other writ petition also.
This is a common order.
Come on, Lordship.
Ah.
Obliged, my
One
Lord.
is for consideration for promotion to the post of junior assistant and another is for section assistant. For promotion, that
For
would.
promotion, Lordship, they will do the need.
I'll settle it. There's no issue, okay?
Deeply obliged, my Lord.
Diploma.
File any of that on you.
Here, Lordship, I have filed my affidavit. They have also filed reply to my affidavit. Lordship may fix the matter some other day for.
Yes, Lordship.
Okay. When
Lordship, after 2 weeks.
parties are represented by the respective councils and they submit that the pleadings are complete. In view of above, list the matter for admission. After 2
Deeply
weeks.
obliged, my Lord.
Obliged.
All right, we'll see. We'll submit next time.
Obliged, my Lord.
Obliged.
It is your lordship.
Yes.
Lordship, I have brought on record a notification by which, my lord, this repetition can be disposed of. Now, maybe due to paucity of.
Not possible today.
That's right. It may be taken up next week, my lord.
As straightforward by the learned counsel for the petitioners, list the matter again on 5/6.
May it please your lordship. Lordship, 2 weeks time may be allowed to file a affidavit in reply, lordship.
As straightforward, 2 weeks time is granted to the petitioner for filing rejoinder.
May I please, my lord?
Yes.
Item number 34, they have not filed their affidavit till date.
Who's the respondent?
Elementary education, my lord, because
Finance also.
when it, after notice, my lord, the first time the matter come.
Okay. As paid for by the respondents, learned counsels for the respondents, for the 3 weeks time is granted
My lord.
to
Obliged.
receive instructions and to file counter affidavit.
Right, my lord.
Yes, Ms. Bose.
May I please, your lordship? I would like to rely upon an order of coordinate bench, lordship.
For what? For disposal?
Yes, lordship.
We are short of time today.
Some other table.
Yes. As paid for by the parties, let the matter be listed again on 12/6.
Difficult.
My lord, let this matter taken, my lord, 12th of June, my lord, because due to
12th of June, possible?
my lord, yes, my lord. Hearing matter, my lord, so there is urgency, my lord.
17.
Any hearing day,
17.
Yes,
It's a Tuesday, I think.
obliged.
As paid for by the
17th June, my lord.
parties, list the matter on 17th of June for hearing.
Obliged, my lord.